My lord, I beg to mention again matter matter to be listed in next week.
What matter? What matter? What matter?
My lord, it is regarding the decree on admission
Okay. Next week.
next week
Next week.
on Tuesday.
On a date to be fixed by registry.
Tuesday, my lord.
Okay, Tuesday.
May please, your lordship. Also with the concern of
Further,
the
my lord. Further, I beg to mention item number 14, today's list, my lord. And though I could not contact the other side, my lord, I am the appellant in this case, my lord. And this matter may kindly also be taken up on next Tuesday, my lord.
You inform the other side.
I will inform.
Okay, next week.
May it
Much
please your lordship. Lordship, bail application number 3513/25 is rejected by your lordship and is a leftover matter, lordship. It's a little urgency is there. Can it be day after tomorrow or Friday, lordship?
No, pray before registry.
Yeah, made a prayer. Application has been filed, but thereafter also not been listed. That is why I'm before your lordship. Kindly, lordship, bail matter, detention,
Okay, on Friday.
right? I'm obliged.
may please, your lordship. Also with the concern of the other side, I beg to mention item number 21, lordship. The dealing counsel is RD Mazumdar out of station, lordship. So the matter
Heard
may-
Mr. S.P. Sharma, learned counsel for the petitioner. Also heard Mr.
Yeah.
K.R. Padgari, learned counsel for the respondent / claimant. Learned counsel for the appellant has prayed for an adjournment on the ground of personal difficulty of the conducting counsel, to which learned counsel for the respondent does not raise any objection. Hence the prayer is allowed. No date. The registry will fix the date.
Also, I have one more prayer, lordship. Also, for listing of 2 MSc appeal, one for orders and one for admission. Lordship, some urgency is there.
Next week.
Next week, lordship. Indeed.
Next week on a
Date may
date.
be fixed, lordship.
Date to be fixed by registry.
Obliged.
May I please, Lordship? Lordship, I have filed an IF for early hearing, Lordship. May I pray for listing next week?
Next week.
May I please, Lordship? May I beg to mention for today, my lord, a criminal, my lord, on 14/11, in a criminal petition order was passed by this honorable court, my lord. But there is some little typographical mistake in order as well as in the petition. If time permits today, my lord.
Okay.
May it pleases your lordship. I beg to mention for listing of an appeal, lordship, matrimonial appeal, lordship,
Next
Right.
week.
next week, as per lordship convenience, Tuesday.
No, registry to fix the date.
Lordship, on 6, the matter was listed and it became leftover, lordship.
No, next week registry will fix the date. We are fixing the week. Let registry fix the date.
The urgency is there, lordship.
May please, your lordship.
And
Mentioning
legally
for-
matter, lordship.
Next week, therefore next week.
To mention for listing of a pending civil revision petition, lordship. There's some urgency in the matter since a temporary injunction granted in our favor has been vacated. Lordship, for hearing. The lordship, I have addressed the registry also through an application, but that has not been listed. Lordship. Any date, lordship, before the vacations also, lordship.
First week of December on a date to be fixed by registry.
Thank you.
Lordship, I beg to mention item number 35 of the supplementary list. Lordship, my senior is not feeling well.
What is your name? You have informed the other side. You have to inform the other side before mentioning an item. Item number 35. We'll allow this, but will not pass orders now. If the matter reaches, we'll adjourn it.
May Lordship, paying for listing an RSA matter, my lord. Pending for 2018, my lord, for hearing, my lord.
First week of December.
Yes, please, your lordship. My lord, item number 26, my lord.
though it is a second appeal, my lord, but it is a matrimonial dispute, my lord. My petition for divorce was, my lord, rejected, my lord, on the ground of jurisdiction, my lord. The honorable civil judge held that the municip has no jurisdiction.
What is your prayer?
Prayer, my lord, since this matter of 2025, my lord, there is little chance of, my lord, reach of this matter today, my lord. So, my lord, my prayer is that, my lord, this matter may be fixed, my lord, on the first week of December, my lord, and the time may be, my lord, fixed at 2 p.m., my lord. Otherwise, it is a 25 matter, my lord.
No,
Well, matrimonial.
so much accommodation is
My lord,
difficult.
both particular young persons, my lord, if the appeal is, my lord, takes so long time, my
Well,
lord.
let it be listed in the first week of December.
My lord, if the time is not given, another same position will be, my lord, in the last, the 25 matters, my lord. It will not reach, my lord. So this is my prayer, my lord. Otherwise, my lord, I will not mention, my lord.
On Tuesday, on that day, you may pray for upgradation with the consent of other side,
Oblige. On 2nd of December,
2nd of December.
oblige.
Yes,
May it please your lordship, I beg to mention one regular second appeal. In this case, all the respondents are notice served except respondent number 1. We want to take Dasti service, lordship. So a order from this court is required. Can it be fixed on Friday, lordship?
orders column,
Orders. column.
orders, okay.
Order RSA 59 of 2019, lordship.
You give the mention, ma'am.
And another matter, lordship, RSA, it was listed for hearing column, lordship, with a fixed matter. And on that day, my learned senior friend is suffering from some illness, so adjournment was taken. Can it be taken on
No fixed, no
Last-
fixed,
week of November, lordship?
no, first week of December,
Lordship. May I
First-
for 2nd of December, lordship.
no fixed date, let the
Lordship,
registry
by
fix. But
applies.
Item, so listing for the Monday on 24th, this is a leftover matter yesterday, item 41. Is I for visiting right of the mother side. Is urgency on. See yesterday matter leftover 41 item. Can it be on 24th, lordship, Monday, next week?
Okay. Interlocutory application,
Yeah.
okay.
May I please, your lordship. Your lordship, I beg to mention for listing a CRP which has not been posting for since 8 November 2024.
First week of December,
That's it.
first week of December on a date to be fixed by registry.
May it please your lordship, I beg to mention an interlocutory application, civil. Any date may be given, this decision.
First week of December,
Oblige. My lord, I beg to mention for listing of the case, it's 18 matters MSC appeal, my lord. So what that may be.
for hearing,
Yes, my lord, because respondent was not turned around, the insurance company, now they have turned around. So that may be given, and they are sufferer.
first week of December,
My date,
no date. Date to be fixed by registry.
my
May it please your lordship, I'm paying for listing a motion matter, transfer petition matter on Friday, lordship permit.
When have you filed?
Yesterday I have filed.
Then why are you mentioning it will be automatically listed within 2 days?
Right.
Wait for that time.
Much obliged.
May I please your lordship, I beg to mention item number 10 of today's list, your lordship. And a compromise has been reached between the parties and the IA has already been filed, your lordship.
But I cannot take up this matter.
Maybe next week before any other bench, your lordship.
The registry to list this matter before any other bench without me, within bracket my name, on in the next week on a date to be fixed by it, as reportedly a compromise has already been reached between the parties.
For the, and for the response.
Heard Mr. S. Sanchit, नाम लिखिबो. J. Mr. Iqbal, your initials are?
My lord, G, yeah.
Mr. G. Imtiaz, learned counsel for the appellant. Also heard Mr. S. Sancheti, learned counsel for respondent number 1. Baki Ketaki.
Hello.
Yes, Your Lordship. Your Lordship, I beg to mention item number 5. Here we have filed one affidavit in opposition, Lordship, that has not been tagged yet. Kindly that may be called for Lordship.
Call for the affidavit.
Lordship, there is one more prayer. I beg to mention one RSA for listing in orders column, Lordship. Can it be on Friday, Lordship?
Okay,
Obviously.
May it please your lordship, I beg to mention one regular first appeal lordship. It may be listed in the admission column lordship.
first week of December, on a date to be fixed by registry.
May it please your lordship. Lordship, I beg to mention for withdrawal lordship, a
When?
transfer petition,
When you want?
tomorrow
Okay. tomorrow.
applies lordship.
May I please your lordship, may I beg to mention for listing of for withdrawal, my lord. Today, my lord, at 2, my lord. Withdrawal
What matter?
AB, my lord, rejected by your lordship, my lord.
Okay,
Obliged, my lord.
fourteen to Likibo on request of London Council for both. Then this matter will be listed in the next week.
Item 28 for withdrawal.
Yes,
Lordship. This is a RSA, the subject matter is related to preemption right, preemption right. The present appellants are the substituted of the original plaintiff appellant. The original suit in the preemption right, the plaintiff got the decree. Thereafter, in the first appeal, the original decree was set aside. And then the present appellant come to this court. While the appeal was pending, the appellant plaintiff expired. And thereafter, the present appellants have been substituted. Then in the meantime, when they were impeded after substitution, they decided were to withdraw this suit because the other defendant, the respondent, is neighbor, and there was some amicable settlement.
okay.
Other, along with
Do you have any objection?
there were litigants, but one of them, this is one of them. They decided together, and because of neighborhood and because of these new circumstances, they decided to withdraw the suit and amicably decided out of the court. And
Okay,
thereafter, they have approached us and instructed us to withdraw. the
okay,
court.
we are allowing. Heard Mr. UC Rabha, learned counsel for the appellant. Also heard Miss, what? S. What is your name?
S. Agarwal lordship.
S. Agarwala, learned counsel for respondent. It is submitted by learned counsel for the appellant that the appellant does not want to pursue this regular second appeal as there has been an amicable settlement between the parties. Stop. The considering the submissions made by learned counsel for the appellant, this regular second appeal is dismissed on withdrawal. Yes,
Obliged.
Item 29.
Please, your lordship, I think it is wrongly listed, your lordship.
wrongly listed means
Lordship, we have not prayed for any withdrawal.
okay. What is your name?
So as Gautam, your lordship.
But we have applied for withdrawal under instruction of my client.
No NOC has been taken, your lordship.
Mr. Rabha, you are for the respondents in this case. Who is for the respondent?
My lord, UC Rabha is.
UC Rabha. Matter 2020 in the same matter, my lord. similar, parties are same, so the case is different.
No, but 28 is withdrawn. You are not withdrawing this.
Yes, my lord, I have received instruction that we don't want to withdraw it anything. And no NOC has been taken from our.
You are for the appellant
Yes, your lord.
in item number 29.
My senior Mr. KK Monto is representing.
Okay. And what's your name? What is
SM Sharma.
SM?
Sharma.
You are for respondent
No, not for for appellant.
and you are for,
For the appellant, your lordship.
why are you on that
My lord,
side?
I was there.
It will give wrong impression to the court. You are representing both same counsel, the same client.
We have been engaged since 2022, your lord.
Okay, your objection is that
We don't have it, we don't want to
your
withdraw.
NOC has not been obtained. A new set of counsel has been engaged by the appellant.
Matter was listed earlier also for withdrawal. It is already in the record, my lord, on 7.
You resolve the issue, you take. The bar council rule says that an NOC has to be obtained from the earlier council. Obtain that NOC. Ask your client to obtain that NOC. Heard, Mr. What is your name?
SM Sharma.
SM Sharma, learned counsel for the appellant, who submits that he has been instructed by the appellant to withdraw the instant appeal. However, Mr. S. Gautam, learned your name is not there in the.
Yes, your lordship. My senior's name, Mr. KK Monto, your lord.
Who is assisting Mr. KK Mahanta, learned senior counsel for the appellant, submits that no NOC has been obtained by the appellant for engaging a new set of lawyers in this case. And they are not aware about withdrawal of the instant appeal. They don't have any instruction regarding withdrawal of any appeal. Stop. It appears that the issue in this case is that as to whether the appellant, while engaging a new set of lawyer, had obtained NOC from his earlier engaged lawyer as required under Bar Council rules. The matter may be resolved by the appellant by obtaining NOC from his earlier engaged counsel. You obtain NOC. If they refuse to give NOC, there are alternative modes provided in Bar Council rules. Follow that.
We have got an agreement also between the parties. We have provided.
No, that is not the issue. They are raising that NOC has not been obtained while you were engaged. Your client has to obtain NOC from the earlier engaged counsel. If he gives NOC, produce that NOC before the court. If you refuse to give that NOC, then also Bar Council of India rules provides what is to be done under such circumstances. Follow that. the council shall accordingly take steps. List this matter. We are listing it in the next week. For withdrawal, you take in, list this matter again in the same column in the next week on a date to be fixed by registry. In between, you resolve the issue of NOC. Yes. Bail here.
Part-third matter, Lordship. Regarding the maintainability of the application, Lordship.
Second half.
Second half, Lordship, I have some prior commitment, Lordship.
No, the petitioners are not there.
So then another date may be given.
Okay. Heard. None has appeared for the petitioner on call. Should I release it from?
Short date may be given.
None has appeared for the petitioner on call. Mr. B. Sharma, learned additional public prosecutor is present. Let this matter be listed on Thursday, 27th.
Take it after some time. I will inform my senior, Mr. HRH, of this matter.
Yes. No. On 25th, we'll fix it on next Tuesday. Next Tuesday. On 25th. As part of matter.
Just having a bit difficulty in conducting the cases at 2 p.m. Lordship. That is why, Lordship, I am.
Okay. On 25th, you have any issue?
2, Lordship, I will have issues. In the morning, I have.
Okay, okay. 25th. Now reflect the name of R. Chaudhary. Miss R. Chaudhary appears for on behalf of Mr. H. R. Chaudhary, learned senior counsel for the petitioner, who submits that and the matter may be taken up after some time. However, considering that this bench is taking up civil roster, this matter is adjourned for the day. Let this matter be listed on 25th as 25th November as part of.
Lordship, kindly pass over the matter for timing.
At 2. At 2.
After some time, at 2 we have another matter.
Okay, after some time. Yes.
May I please, Lord. Not here, my lord, second time petition, my lord. Here, my lord, the victim is a student, my lord. And petitioner is a teacher. He is about to retire, my lord.
Nalbari, Munsif number 1 Nalbari, which was registered as title suit number 57 of 2015.
Against defendant number 2.
Against defendant number 2 only.
That suit was for?
It was for declaration of right of interest, confirmation of possession, permanent injunction.
This was prior to your sale of land.
This was after selling out. This suit was filed in the year 2015 and sale deed was executed in the year 2010. That is after 5 years later from the date of execution of my.
In respect of which land?
In respect of only Schedule A land.
Now, Schedule A land you have already alienated to the plaintiff.
Yes.
In 2010.
Yes, Lord.
Then why you preferred a separate suit?
the suit preferred by same plaintiff. That is respondent number 1 of this revision petition. Same plaintiff. That suit was preferred in the year 2015.
The,
In that suit, even I did not.
this
proceed as
title
party.
suit 57 of 2015 was preferred by the plaintiff.
Against defendant number 2
Oh,
only.
okay.
I was not implicated as party in that suit.
Okay.
Then Lordship, kindly peruse from line 9. Start in from the top Lordship. In the said title suit. Lordship got it. From 9th line. In the said title suit, the defendant number 2 took stand. The defendant number 2 contested in the suit and took stand that it was his own land pertain to Dag number 173 of NK Patta number 64, and the suit land is not the land of the defendant number 1, the vendor of the suit land.
Where are you reading?
From 9th line.
Era?
Same page 26 from the top. So
Okay.
the title suit number 57 of 2015 after that lot.
Okay.
May I read again? Lord?
No. He took the plea that it was not the land
Yes,
which were,
that land was not covered under Dag number 175. Rather, that land was covered under Dag number 173. That was the stand taken by the present defendant number 2 in title suit number 57 of 2015.
according to defendant number 2 in the Act number 170.
Of NK Patta number 64 was in the west side of Dag number 175 of NK Patta number 18. It does exist adjacently. It is stated that the defendant number 2 also raised that the question that the suit land is undervalued, though the value of the suit have been on the purchase value of the land. Accordingly, the question of the value touched the jurisdiction of the court, and the plaintiff sought for withdrawal of the said suit with a liberty to file afresh, which the learned court of Munship number 1 Nalbari allowed, and hence this suit has been preferred against the vendor of the suit land as well as defendant number 2.
Okay. The title suit.
On the basis of stand of the defendant number 2, Lordship, that earlier case was withdrawn and this case has been filed, impleading myself as defendant number 1. And kindly peruse why they involve Schedule B. Lordship will find at page paragraph 8.
Yes.
That the defendant number 2 stand, if so found to be correct after trial of the suit.
Schedule A land is covered by Dag number
175.
173.
175, Lordship, as per plan.
175.
It was the claim of the defendant number 2 that that land is not covered
175.
under 175.
Patta number?
Patta number 18, Lordship.
What is Patta number 64?
That was the stand of the defendant number 2. So their stand was suit land wrongly described. Rather, the suit land is covered
What
under
was the description of the suit land in the sale deed? Of your sale deed?
175 of Patta number 18.
Okay. And position was also handed.
Handed over, mutation done,
Okay,
development has been,
Now they have taken a different stand.
yes, by the defendant number 2 side.
And the plea of the defendant number 2 is that that land is not covered under Dag number 175,
Yes, Lord.
but under Dag number 173,
Of KP Patta number 64.
64. Okay. Then
Then kindly peruse paragraph 8, Lordship. they unnecessarily involve my another property, that is schedule B.
Yes.
Description is there in paragraph 8. That the defendant number 2 stand, if so found to be correct after trial of the suit, then it would be clear that the plaintiff had wrongly shown the boundary of the land either deliberately or unintentionally, with the belief that the her land is covered Dag number 175 of MK Patta number 18 of Ward 7 Nalbari town stretched to the suit land, and with that belief she had transferred the suit land. Accordingly, in that case, the plaintiff will be entitled to the land of the plaintiff, which is in Schedule B. And to that extent, the sale deeds. Next page, Lordship.
Yes.
The sale deeds has to be corrected by incorporating 1 katha 10 lashes of land out of Schedule B of the defendant number 1, and to hand over possession of the said land with distinguished boundary, and during pendency of the suit, until such correction of the sale deed and handing over possession of the land is done by the defendant number 1, the defendant number 1 should be restrained from alienating, transferring of right title and any sort of interest of the Schedule B land. So on the other hand, if it is proved that the suit land belong to defendant
Schedule
number
B
1,
land is in your possession.
Lordship,
Schedule B land is
yes,
in your.
that is different plot. That is situated after whole plot of the Schedule A land.
Okay.
Lordship, next part, Lordship. On the other hand, if it is proved that the suit land belong to defendant number 1, she rightly transferred the suit to the plaintiff shall be entitled to the possession with her right title interest. Accordingly, during pendency of the suit, status quo shall be maintained by the parties to the suit land in respect of Schedule A and the Schedule B land.
Now Schedule A land is in possession of.
The plaintiff side,
Defend,
Lordship.
no, Schedule A land is possession of defendant number 2.
No, Lordship, because recovery of prayer of recovery of possession is not there. The prayer is there only not to disturb peaceful possession of the plaintiff side.
No, but in their suit, in their plaint, they have stated that the defendant number 2 had dispossessed them
So here, Lordship,
by
kindly
breaking.
please, prayer number 1, 2.
No, I'm not going to the
Yes,
prayer.
yes,
In the body of the plaint,
yes, Lord.
they have stated that defendant number 2 had dispossessed them.
Statement is there on Lordship 28/1/2013.
Yes. So after that, whether there was recovery of possession.
That prayer is there in prayer number 1 at page 28.
They are seeking confirmation of possession.
Not only confirmation of possession, decree of right title interest and for khas possession in respect of suit land.
Suit land is Schedule A land.
A land.
Suit land is according to their averments made in the plain.
Yes, sir.
They were dispossessed on
2013.
23/1/2000.
28/1/2013.
And thereafter, there was no averment regarding recovery of possession.
That specific
Averment is not there. Still, they have prayed for confirmation of possession of.
Not exactly confirmation of possession, right title interest of possession.
Recovery of position.
Whose possession?
Possession means vacant possession. My limited knowledge.
Vacant position, the recovery of position that.
From defendant number
Yes, sir.
2.
Different number 2.
Okay,
Implied limit.
okay, yes.
Then kindly here one part interesting, Lordships. This present suit is preferred after withdrawal of first
So-
suit.
So alternative prayers are made. That
Yes, sir.
if it is found
Wrong.
that the description is wrong, then the deed has to be rectified.
Yes,
Or else if the deed is found to be correct, then recovery of possession.
yes, Lord. In the plan regarding Schedule B, case is speculative based on the result of Schedule A.
Yes.
So here, interestingly, Schedule B land measuring 4 katha, and the plaintiff needs 1 katha 10 lesa.
Schedule B land is 4 kota. And Schedule A land is 1 kota 10 lecha.
1 katha 10 lesa.
Okay.
And there, interestingly, Lordship, first suit was preferred in the year 2015, that was withdrawn. Then the present suit was preferred in the year 2018. And interestingly, that cause of action arose on 28/1/2013. Suit was preferred after 5 years. And that is the only cause of action.
So what is the submission? Still it is not barred by limitation.
No, not only limitation, for considering injunction, there must be serious question of.
Now, what
adjudication.
injunction has been granted?
Yes.
Status quo in respect
I will
of,
show, Lord. I will show.
status quo in respect of schedule.
Both property.
You are aggrieved by status quo in respect of schedule B land.
Yes, exactly, Lordship. This is complete different plot of land. This is not only my land. My sister are also owners.
Okay.
And my sisters were not implemented as party to this proceeding. And Lordship, there must be right. What
Okay.
right the plaintiff have over Schedule B property? Is there any contract?
No, what was the observation of the appellate court in your appeal,
Very
misappeal
well,
4?
Lordship. I will show continuously, Lordship, after showing the order passed by learned trial court.
Okay.
And kindly peruse before it, page number 27, cause of action. So should file only on that cause of action.
And in that cause of action, they have alleged that defendant number 2 has encroached their property.
Yes, specifically, the cause of action of the suit arose on 28/1/2013, while the defendant number 2 disposes the plaintiff from the suit land. On subsequent dates, while the defendant number 2 claimed the suit land belonging to them, not defendant number 1. So
Okay.
cause of action against defendant number 2, not against me.
Okay.
Allegation against defendant number 2, not against me. Rather, I help them to protect the property while defendant number 2 tried to dispose them. So Lordship, as per principle of section 34 of specific relief act, to seek a declaration of right title interest, someone must deny right title interest. Then those party are necessary party for proper and adjudication of the suit. At least they made myself party as pro forma defendant to support their claim. So no cause of action against me, no allegation apprehension against me in this suit, Lordship.
No, one averment is there that you might have wrongly identified your,
That is speculative.
wrongly described the suit land in your sale deed.
Lordship,
That is speculative.
Yes, Lordship. So on that ground, Lordship, another property, without, in fact, defendant plaintiff did not bring any document in respect of Schedule B property. No patta, jamabandi, sitha, nothing is there in the suit. No contract with me, Lordship. And cause of action arose in the year 2013. Suit filed after gap of 5 years, only on that cause of action.
Still status quo was granted.
Yes, Lordship, without considering the basic principle as required under Order 39, Rule 1 and 2.
Okay.
Now kindly peruse for a moment. Lordship.
You are aggrieved with the status quo in respect of schedule B land. only.
I am specially against Schedule B.
B land, okay. Now, yeah,
Plaintiff did not made out any case in respect of Schedule B
land.
property.
And the averment he made in his claim are according to you speculative.
Yes, Lordship.
Okay. Yes,
Now kindly peruse the sale deed, Lordship. Annexure 4, page number 43. That is admitted.
sale deed is in respect of
Schedule A.
Schedule A, that is,
Yes, executed by present
that is
petitioner.
Dag number
175.
175.
Yes. Lordship will find schedule at page 44 with 4 boundaries, including length and breadth. If your lordship, just below the boundaries, the length of the land is 144 feet and breadth is 30 feet. Not only boundary were described, lordship. Length and breadth also were there.
Yes.
Accordingly, on this 4 boundary, the plaintiff, the defendant number 1 handed over the suit property. They muted, they developed, they continuously possessed up to the date of cause of action peacefully.
Yes.
Then kindly peruse my written statement, if your lordship. Written statement, lordship, at page 37. The grounds were taken. If your lordship just time only, I want to read paragraph 1, lordship. At page 37 and except 3.
Why you have filed 2 CRPs?
Lordship, here 2 defendants are there. After passing injunction, disposal of injunction order, I preferred miscellaneous appeal 4 of 2018, which was disposed of on 17/2/2020.
Yes.
Then the second miscellaneous appeal preferred by the defendant number 2,
Yes, 5.
5. That was disposed of on 7/12/2020. And while passed the judgment in miscellaneous appeal 5 of 18, the first appellate court reviewed the order passed in miscellaneous 4
How
of
it reviewed?
2018.
What was the order in 4?
Order of miscellaneous.
In
appeal.
4, your appeal was
Yes, sir.
dismissed.
Lordship will find effective court at page number 76. So before coming to
No,
this order, if your lordship,
no, I will come to you. But what was the final order? It upheld the status quo.
yes, learned trial court granted status quo without considering my written objection as well as submission. Learned trial court discussed only the case of the plaintiff as well as defendant number 2.
And in respect of Schedule B,
Yes. Vague order is there to maintain status quo.
what was the reasoning?
Yes, lordship will find injunction order. Page number 66, lordship. Effective for lordship will find at page 70.
No, we will go through it, but tell me the gist. What was the reasoning on
That
which?
region, lordship, no specific discussion is there as required under order 39 rule 1 and 2. Just discuss the case of plaintiff and this objection of the defendant number 2 and met this. It is held at page number 70. Paragraph 2, start from in the previous suit.
Page 70 in the, yes, in the previous suit.
Married, Lordship.
Yes, please read.
In the previous suit,
This is trial court's order.
trial court's order.
Okay.
In the previous suit, the petitioner claimed for eviction of the opposite party from the suit land, and in the present suit, the petitioner has claimed for declaration of a right title interest, possession and partition of land in Dock number 175 covered by Dock number 118 of Nalbari town. As such, according to defendant opposite party, the plaintiff has failed to make a prima facie case. Then the plaintiff petitioner have filed the suit praying for declaration of right title interest, khas possession and injunction, and also for other consequential relief. I have perused title suit 1 of 2018 and the document relied upon by the plaintiff petitioner. I found that the petitioner have got prima facie case, though both the parties are claiming the suit land to be their property. Actually, I am not claiming, Lordship. The right of the parties are yet to be determined. Considering the nature of allegation made by the parties regarding possession and right over the suit land, I find that the suit land needs to be preserved till disposal of the suit. Hence, both the parties are directed to maintain status quo relating to the suit land as mentioned in Schedule A and B of the petition. The parties are restrained from making any alteration in the nature of the suit land or alienation of the suit land and maintaining status quo over.
So B was also included.
Yes, Lordship. So what irreparable loss and injury, what prima facie, so
Not
what
this.
balance of convenience,
How
nothing
there
has
is,
been
how there is prima facie case
Yeah,
in respect of Schedule B land that has not been.
not been discussed. Even
Okay, okay.
the statement taken in the written objection by the defendant
And
number one.
how
that was
the,
also
how the
discussed.
first appellate court dealt with it?
Then
issue?
kindly peruse first appellate court judgment, Lordship will find annexure 8, start from page 71, effective court, Lordship, at page 76.
Yes, 76.
Paragraph 10, Lordship. Same mechanical order. Married, Lordship.
Yes.
The fact appearing shown that there is a wrong quotation of description of the land in cell deed, which is mentioned by the vendor in cell deed number so and so, and sold by the present appellant to Rita Bosha Talukdar. So that cannot.
That
help,
is an
Lordship.
averment only.
Yes, Lordship. It is, yes, Lordship. So that cannot help without trial, Lordship, without evidence.
So on what basis? Okay, okay. That was the averment only made in the plain.
Yes, Lordship.
That if it is found that there is,
If it is found, your court held it without evidence, Lordship.
okay.
The acceptance of the consideration money, execution of cell deed number so and so has been proved from the statement of the appellant Kiranmoy Chaudhary and transferring of her share of land measuring 1 katha 10 lasses covered by dock number 175 in favor of respondent number 1, Rita Bosha Talukdar, is also proved, and same is an admitted fact. The crucial point appeared in the suit is that the land which is mentioned in the sale deed does not fall in dock number 175. It is a land of dock number 173, and the present appellant is owner of the land mentioned in Schedule B, which is covered by dock number 175. And the respondent number 1, Rita Bosha Talukdar, submitted in her suit and petition that if the claim of the respondent number 2, Oli Das, has proved, and the land mentioned by her in the plan which she has purchased from opposite party number 1, that is the present appellant, is covered by Dag number 173 and is the land of respondent number 2, only thus then the opposite party Kiranmoy Chaudhary, that is the present appellant, is required to correct the sale deed and deliver possession of land measuring 1 katha 10 lesas. Next page, Lordship.
Yes.
1 katha 10 lesser of Dag number 175 in her favor, which she mentioned in Schedule B of the plant and petition. For that reason of both the schedule needs to be protected from transferring, alienating, changing as to keep its present status at the time of filing the suit to protect the just right of the petitioner plaintiff. So here in between, it is also held that the land is covered, suit land is covered, Dag number 175. That is also held, Lordship, without trial. Then paragraph 11, upon perusal of the entire record, I find the respondent number 1 has prima facie case to go for trial, balance of convenience in favor of in her favor, and if the opposite party are not restrained from the alienating the suit land, then it would be
Just a minute. In the sale deed, the Dag was 173,
175, Lordship,
175. Patta was
18.
18. And Schedule B land is Dag number.
Same duck, same patta, but after 4 plots of land.
Not same patta, separate.
If I am not mistaken, same patta.
No, Dag number is different.
Okay, patta number 18
If you have
and 64.
Schedule B, Lordship,
And
will find that
Schedule A land is?
same duck, same patta, both property, Lordship. As per plan, Lordship will find at page number
No,
29.
not as per plan, as per sale deed.
As per sale date 175, Dag number 175, patta number 18.
What is 173?
173 claimed by defendant number 2 without any counter claim, without challenging my sale date. They are sale date.
173 is the description of Dag number and the Schedule A or Schedule B land.
Not schedule A, not schedule B, Lordship. It is the only claim from defendant number 2 side, without any counter.
In respect of which land?
Adjacent land. According to them, 173 situated adjacent to 175.
It is the claim of the defendant number 2 regarding that the land sold to me, that falls under Dag number 173 of patta number 64. That is the plea of the defendant number 2. After my purchase, the land was reported to be, in earlier case, which was withdrawn, reported to be the.
That is what I am asking. According to sale deed, the Schedule A land is Dag number 175, patta number 18.
Yes, sir.
According to defendant number 2, Schedule A land is covered by Dag number 173,
Patta number 64.
patta number 64.
That is the claim of defendant number 2 side.
Okay.
There is no description in their written statement within 4 boundary, Dag number, patta number, no counter claim, nothing is there. Only defense.
Okay.
Sale deed is also not under challenge. Mutation not challenge.
And Schedule B land is Dag number 175.
175.
Patta
Same patta 18. Situated after 4 plots of Schedule A land.
But the boundaries are different.
Boundaries are also different. It's a huge patta also. Kindly peruse last part. paragraph 12. And that finding was reviewed in subsequent then
Yes,
paragraph 12, Lordship, page number 77.
yes.
In the light of above discussion, I find from the materials on record that the learned civil judge rightly passed the order directing the parties to maintain status quo in respect of suit land mentioned in Schedule A and B of the plan petition and restrain the parties from alienating transferring of the suit land till disposal of the main suit, and accordingly order passed by the civil judge on 26/6/2018 in miscellaneous case number 4 of 2018 is upheld, and present appeal has no merit and is dismissed no cost. Then kindly peruse judgment of miscellaneous appeal 5 of 2018. Lordship will find at page 80. And effective-
In this CRP, you have impugned the order of the order dated 17/2/2020,
Yes, in revision 65 of 20.
first revision.
Yes, Lord.
Okay.
And then kindly peruse annexure 10, page 80. Judgment and order passed in miscellaneous appeal 5 of 18.
Yes,
Effective part, Lordship, will find that page number 86, paragraph 12.
yes,
Mary Lord.
yes.
The fact of the presence of present appeal is not brought at the time of disposal of miscellaneous appeal 4 of 2018 arising out of title suit number 1 of 2018. The present miscellaneous appeal 5 of 18 and
These were filed simultaneously.
Yes, Lordship.
Okay. Yes,
Miscellaneous appeal 5 of 18 and miscellaneous appeal 4 of 18 are arising out of same suit. Miss case number 4 of 18 and title suit number 1 of 18. The suit property in both the miscellaneous appeal 4 of 18 and 5 of 18 are same, and both appeal filed against same order dated 26/6/2018 passed in Miss J case number 4 of 2018. Accordingly, order passed in Miss appeal number 4 of 2018 is so motu reviewed. In terms of the order of the present miscellaneous appeal 4 of 2018 to avoid conflict in the order of same court passed in same proceeding, however, filed by two set of defendants separately against the same order. So, Lordship, what happened? The earlier order, whereby status quo order was passed in respect of both property, here interestingly, if your Lordship kindly peruse paragraph 11, I read paragraph 12 to know the strategy. What was the strategy? Kindly peruse paragraph 11, what was modified.
yes.
Upon perusal of the entire material available on record, I find that the respondent number 1 neither purchased land of Dag number 173, nor is the owner of Dag number 173. She has no right to restrain the original owner from his peaceful possession. The respondent number 1, Rita Boisya Talukdar, purchased land of Dag number 175 from respondent number 2, Kiranmoy Chaudhary. And the respondent number 1, Rita Boisya Talukdar, mentioned land of Dag number 175 of NK Patta number 18 in the Schedule B of her plan petition. It is the respondent number 2, Kiranmoy Chaudhary, who gives a wrong description of the land in the suit land.
How
When-
this finding was?
Yes, Lordship. In miscellaneous appeal under order 43 rule 1, Lordship. May I read, Lordship?
Yes,
When she transferred the land of Dag number 175 of MK Patta number 18, measuring 1 Katha 10 lesas to Rita Bosya Talukdar by executing registered sale deed, void number so and so, and the fact is now clear from the materials on record. As such, the respondent number 2, Kiranmoy Chaudhary, has to compensate the plaintiff, petitioner Rita Bosya, from her own share of the property, and for that reason, the plaintiff Rita Bosya Talukdar cannot claim the property of third person, and accordingly impugn order 26/6/2018 passed by the learned trial court in miscase number so and so, arising out title suit number so and so, is modified to the extent that the respondent number 2, Kiranmoy Chaudhary, her relative, agent, man, servant, attorney, etc., under her or other is restrained from transferring, alienating the Schedule B land in the planned petition, and from changing nature and character of Schedule B land mentioned in the planned petition of title suit so and so, miscase so and so, till disposal of the main suit. The interesting part, remaining part, the land of Schedule A is released and status quo to be maintained in respect of Schedule B only, Lordship.
Oh,
The earlier order passed in miscase number,
so the
4
trial court
2018 was
arrived at
reviewed.
a finding, final finding
Yes, Lordship.
in the miscase itself.
Yes, Lordship. So order 41 rule, order 43 rule 1 cannot allow, does not allow such power to an appellate court. So in fact, appeal is concerned against injunction, the power of appellate court is very limited, Lordship. Now, if your honor kindly peruse the injunction application, whether the plaintiff petitioner should all establish all three principles required to grant an injunction order 39 rule 1 and 2. Now kindly peruse injunction application. Lordship will find at page 30. The statement.
This misappeal 5's judgment has been challenged in the second revision petition.
Exactly.
And in the first revision petition, your grievance is only to the
Judgment and
to
order
the-
passed in miscellaneous 4 of 2018.
to the extent of its affecting Schedule B property only.
Lordship. But as on that, the order passed in 4 of
Has been reviewed.
2018, it's become meaningless, Lordship. It become infructuous in view of using power of review.
Yes. Though only an alternative prayer was made.
Yes, Lordship. Without any document, single document has not been
Okay.
filed sir, before trial court in respect of Schedule B property.
Yes.
If your Lordship kindly peruse their injunction application, they fail to show all three principles required under Order 39 Rule 1 and 2. The statement made in the plan from paragraph 1 to 8 is similar to the injunction application. Only they have added paragraph 9. Rest are similar.
Page
Start from page 30.
Page 30.
30, Lordship. Similar statement up to paragraph 8. And only new paragraph Lordship will find at paragraph 9 at page 35. I've already read the plan, paragraph 1 to 8. Here only paragraph 9 is there, and mechanical prayer, Lordship, to issue ex parte ad interim injunction against respondent number 1 and 2 to restrain themselves from alienating, selling, transferring, the schedule A and B. Whereas against respondent number one lordship,
Now,
no allegations are there. No allegations are there.
same accusation that on
Only
17,
28/1/2013
28, 113.
against only defendant number 2. Rather, the plaintiff admitted my brother, myself, and my husband cooperated him to protect his possession over Schedule A when that cause of action were arise.
Okay.
So, my humble and respectful submission, Lordship, there is no case made out against the present petitioner.
In respect of Schedule B land.
Yes, Lordship. So now Schedule B admittedly, Your Honor, consists of 4 kathas of land. Now, since 2018, that property is confined also due to this order passed by learned trial court as well.
Otherwise, it is in your possession.
It is my possession.
You are using it.
Yes, Lordship.
Only restraint is that you cannot alienate it.
Yes, Lordship. Speculative ground.
Yes.
I have some judgment if necessary, Lordship. I will.
Judgment on what point?
Honorable Supreme Court Lordship knows the power of appellate court to use review. The 2 judgment is there of Honorable Supreme Court, and in connection with Order 39, Rule 1 and 2, I want to place some judgment, Lordship. This is Dalatpar Kumar as well as Gujarat Coupling. Both are famous case, Lordship. If necessary, I will place it.
Yes. What is the submission?
What I submit in this case, my lord, that we purchased the land fairly and with an innocuous purpose, and we have originally at the inception, we did not have any grievance against the defendant number 1 because she sold out the land and we
No, your basis of your claim of right title and interest
yes, ma'am.
is the sale deed
Sale deed, ma'am.
and the mutation order,
Yes,
which is in respect of,
we have stated in our plan,
which is in respect of
schedule A land,
land covered by DAG number 173,
175. ma'am.
not 175.
Yes, 175, my lord, pata number 18, what is written in our sale deed?
No, your sale deed is in respect of 173 only.
175.
175,
Sale deed in respect of,
175.
yes. Where is the sale deed?
Sale deed is not there. Next one.
Fine, next Lordship, Lordship, fine, at page 43. Schedule Lordship will find at page 44. '73 is concerned 173, that is the stand of defendant number 2, Lordship.
Yes, what is the contention?
My lord, we purchased this land, my lord. Admittedly, we purchased from the defendant number one in this case, my lord. But subsequently, while we took possession and after taking possession, we erected a wall and etc. and fencing. Then, my lord, the defendant number 2 came and he asserted that it is his land. It falls under DAG number 173 or pata number 64. And it is adjacent plot of land of the appellant, the defendant number 1. So, after disposition, my lord, one suit was filed Then in that suit also a report of the commission report came, my lord, that the particular land falls under 173, down number 173 and pata number 64. And after that, my
Of
lord,
which the position was,
my lord,
the position was handed over.
my lord, at that time we were dispossessed, and then we filed a suit, my lord. The suit number 57, I think, my lord, of 2015. And that suit was withdrawn, my lord, subsequently because of the jurisdictional aspect regarding valuation of the suit, my lord. Then it was allowed.
Where is the report of Amin Commissioner?
It is not here, my lord. In that suit, my lord.
That is also not exhibited while I crossed the PW side.
My lord,
Not in the case record.
it is,
That
it
is
was,
only the
it
stand
was,
of defendant number 2.
it was the stand of the defendant number 2, admittedly.
Defendant
And we are not on that, my lord. Till today, my lord, if it is, my lord, we think that if it is the land falls under DAG number 175 and pata number 18, then that land we have sought relief in respect of that, my lord. If the defendant number 1 has wrongly inserted a pata number and DAG number in respect of the Schedule A land, then we have sought relief or alternative relief. And in that respect, my lord, at present to before trial, nobody can say, my lord, what land will be of whose part. My lord, after trial, it will be concluded, my lord, whether the Schedule A land belongs to defendant number 1 or not, my lord. If Schedule A land defendant number belongs to defendant number 1, then certainly we get the land, my lord, with first position. That is the case, my lord. So that is why, my lord, and if the Schedule A land is not of defendant number 1, then we have prayed, my lord, correction of sale deed, that she has got 4 kotha of land, adjacent land, and out of that she should have executed the sale deed, but it was not done, and it may be a higher mistake, or deliberately it was done. That is the case, my lord. So both the plot Schedule A and Schedule B land, my lord, should remain, my lord, under status quo, my lord. Because if during pendency of the suit, my lord, it is alienated, then we will suffer, my lord. And apart from this, my lord, the principle of lease pendants, even if the status quo order is not passed, my lord, it is the duty of the parties concerned to maintain status quo until the dispute is resolved, my lord. So I need not to submit much more, my lord, regarding facts. My learned brother has submitted already regarding entire facts. The principles regarding maintaining of status quo, my lord, that is to be looked into, my lord. This is my submission before this honorable court. And regarding, my lord, the other appeal, review of the appeal releasing the Schedule B property, my lord, Schedule A property, we have not filed any remedial application, my lord, regarding revision application against that. And since the suit is going on at present, my lord, at the evidence stage, so we have not submitted any revision application against it.
You, Mr. Ali, you give me gist of your submissions. Point was 1 page. And supporting rulings which you are relying. You may also give a written gist.
Yes.
In the next week. Heard Mr. Both the cases together. Heard Mr. R. Ali. Learned counsel for the petitioner, also heard Mr. P. Chaudhary, learned counsel for the respondent. Hearing concluded. Though hearing is concluded, however, learned counsel for both sides are requested to submit a list of their submissions in writing, 1 or 2 page only, along with the supporting rulings. Let this matter be listed again on, when can you file? Okay.
Monday.
Monday is, let this matter be listed again on 24th of November.
24 November, I have some problem, thereafter.
Tuesday
any date,
date. 20, Tuesday date,
26.
26th of November.
Copy.
Okay. List accordingly. Is list was-
Hello. Before my learned can proceed, madam, I want to make a submission, madam.
Yes.
The matter was earlier placed before the mediation phase, matter. The matter relating to the payment of some attending bills, my lord, between some contractual bill. I am the employer. Recently, I have some instruction from my client. So there is some possibility of settlement, my lord. So therefore, may I seek only 1 week time, my lord? If
You are ready to pay. You are ready to pay the outstanding bill.
some possibility, my lord, because
So if there is a possibility,
only 1 week time, my lord.
So let it be on Monday next year, okay? On 24th, if that is there, because mediation failed. It was
Yes, sir.
3 sittings, 4 sittings.
but still he is,
As he has given the offer, your lordship, at least on 24th, it may be taken up, your lord.
That will be the last chance, my lord.
24th or 25th, any date, your lord.
Any date, my lord. next.
total date at all.
24th.
Heard Mr. A. Bishwas, both cases together. And both are same matters.
Yes, your
Same
lord.
date.
A. Bishwas, learned counsel for the petitioner, appellant / petitioner. Second one is a CRPIO
Yes.
in respect of a specific order. Okay. Also heard Mr. S. M. Borwa, learned counsel for the respondent, who submits that though this matter was referred to mediation, and though after 2 or 3 sittings, the parties failed to arrive at a amicable settlement. However, he has been instructed by the respondent that there is a possibility of arriving at some settlement and regarding payment of outstanding dues to the appellant. And therefore he seeks a week's time so that the said possibility may be explored. Learned counsel for the petitioner, considering the submissions made by the respondents, learned counsel, raises no objection. Let this matter be listed. No. Agot Nori. 26th. 26th of November.
Item 5.
Obliged.
May I please your lordship? So in this case, against the order of granting injunction, the respondent number 1 and 2 lordship,
Item 5, you have mentioned, Consular.
so that they have for calling that affidavit in opposition.
Right.
They have filed an opposition, it is on record. Let the matter be fixed on day after tomorrow lordship on a hearing day for final disposal. Because they have have the copy yesterday, lordship. I received it.
Not day after tomorrow, as per. Kita Dipapali. 2nd December.
If they have from 28 to 5th December, I'll be out of prison before that. 28, before 28. lordship. Any hearing day,
Or after 6,
lordship, before
before 28th. Heard Mr. P.P. Datta, learned counsel for the
appellant, lordship.
appellant. None has appeared for the respondent on call. Learned counsel for the appellant submits that this matter may be finally disposed of at the admission hearing stage itself, and therefore requests to fix this matter on 27th of November. The prayer is allowed. Let this matter be listed accordingly.
Lordship, Mr. Sarfraz Nawaz is on his legs in another court. Kindly pass over for the time.
Let him come. Let him come. You have spoken to the amicus. Okay, let him come. We'll take.
Hearing on number 41. Item 11.
May it please your lordship. Here, we are challenging the decree of reversal asked by the learned additional district judge. The decree dated 23/12, the decree dated 6/6/2025. And our substantial.
Who is
question-
appearing for?
Today is the first day. Notice.
But on last date,
Last date, we had taken, sought for adjournment.
but the order says one Mr. K. Kolita appeared.
We are appearing for the respondent lordship.
Yeah.
Senior Mr. K. Kalita is on legs in court number 18 lordship. So let the matter be passed over for the time being. Lord.
Okay. Let him come.
Court hearing item 12.
Lordship, my senior is on the way.
Rejectment suit against that, the revision is there. Both the court, trial court as well as the appellate court had decided that the tenant was a defaulter and there was a bona fide need for the premises to the landlord. Against that, this revision petition. So may I start with the judgment, my lord? May I read the judgment?
You can at least, he's on the way.
Yes.
You,
Let
till
him-
he arrives, you can tell me the facts.
Yes, my lord, the fact is that, my lord, the tenanted premises is the soap.
Or we can
premises.
go through the judgment.
Yes. That the improved judgment of the trial court at page 49.
start from page 50.
Merely, Lordship, the judgment.
Yes.
The plaintiff's story in brief is like the plaintiff number one is the landlord of the defendant, and their tenancy was created by a written agreement dated 1/4/2008 at a monthly rent of rupees 5,321 with clause of increment in rent at the rate of 15% every after 3 years, with a further clause for termination of tenancy after expiry of 3 years by giving termination notice. Being the landlord, the plaintiff on expiry of the 3 years of tenancy.
It is in respect of what is the schedule property
The shop premises, Your Lordship.
shop
The
premise.
commercial.
Okay.
Being the landlord, the plaintiff on expiry of the 3 years of tenancy wishes not to renew the tenancy further as the tenancy premises was required for their own use. The plaintiffs have bona fide requirement of the tenanted premises, so the plaintiffs served the termination notice in respect of the tenancy on 18/3/2011 by registered post requesting the defendant to vacate the tenanted premises by the end of 31/3/2011. But the defendant on receipt of the notice filed a suit being title suit number 133 of 2011 in the court of Munship number 2 at Guwahati, questioning the validity of the said notice as well as terms and conditions of tenancy agreement, and further brought allegations of forceful and illegal eviction of defendant from suit premises with the plaintiff. The present plaintiff contested the said suit as the defendant, and finally the suit was decreed in part, holding that the tenants were entitled to occupy the tenanted premises until he is evicted by due process of law, and further also held that the terms and conditions of the tenancy was not illegal, and clause 2 of the said tenancy agreement was found in accordance with law. Thereafter, the plaintiffs have filed the present suit against the defendant for eviction both on ground of default in payment of the rent since 1/4/2011 and also on bona fide requirement of the suit premises. The defendant appeared in pursuance of summons and contested the suit by filing written statement and adducing evidences. The defendant has denied all the allegations brought by the plaintiff and also denied the claims assertions, that is defaulter as well as having such bona fide requirement for the plaintiff in respect of the suit premises. The defendant has stated that most of terms and conditions of tenancy agreement relating to the period of tenancy, enhancement of the rate and termination of the tenancy, etc. are illegal and contrary to the law relating to tenancy. Therefore, the defendant cannot be evicted so long he pays the full rent to the plaintiff. He has also stated that although in the said tenancy agreement, it was mentioned that the rent is to be paid in the first week of the following month as per English calendar against valid written receipts from the landlords, and no payment by banks checks shall be recognized as rent payment unless a formal written receipt acknowledging payment of the rent is obtained from the landlords and until the check is collected from the bank. However, the landlord plaintiff, after entering into said tenancy agreement, always collected the rent from the defendant by the check and never adopted the practice of issuing rent receipt to the defendant tenant in spite of demand made to that effect by the defendant. In addition to that, the plaintiff on many occasions collected the rent for several months together. As for instance, collected the monthly rents by check on 4/9/2009 for 3 months together. That is on 25/11/2009, collected the monthly rent by check for 3 months together. On 16/3/2010, collected the monthly rent for 2 months together by a check. On 3/4/2010, collected the rent for 2 months together. On 6/10/2010, collected rent for 3 months together. On 17/12/2010, collected the monthly rent for 2 months together. This goes on. Thus, the plaintiff had collected the rent up to March 2011 and no such terms and conditions for paying the rent complied by the parties. Therefore, the defendant is not liable to be evicted from the suit premises. The tenanted premises were not let out to the defendant for 3 years only. By reserving the scope of getting back the suit premises for the purpose to use it in future expense of plaintiff's own business, hence the plaintiff is not entitled to get the tenanted premises back as asserted by the plaintiffs. There is also no mutual understanding between them that the defendant will vacate the suit premises as and when the plaintiff asks for vacation of the same. The plaintiffs have sufficient place for their business and also for expansion of their business and to keep their merchandise. Therefore, no such bona fide requirement of plaintiffs with regard to the suit premises. The defendant had to deposit the rent with effect from April 2011 till date in court through miscellaneous NJ cases when the plaintiff refused to receive the rent from the defendant for the month of April 2011. The defendant is not a defaulter in paying the rent for any month as asserted by the plaintiff. Thus, the defendant prayed to dismiss the suit with cause. Then the issues of Premier Lordship. The first issue is whether the suit is maintainable, whether the defendant is defaulter in the payment of rent, whether the suit premise is bona fide required by the plaintiffs for their own use and occupation, whether the plaintiff is entitled to be relieved as prayed for, to what other reliefs, if any, the party is entitled to. In order to prove the asserted facts claim, both the sides have adduced evidences and exhibited documents as follows. The plaintiff side exhibited as many as 10 number of documents. PW1 Abhishek More.
What was ultimately held on defaulter ground?
Defaulter and bona fide requirement.
Both on both count.
Exhibit 1 tenancy agreement dated 1/4/2008. Exhibit 2 notice of termination dated 18/3/2011 issued by the plaintiff, which was received by the defendant. Exhibit 3 counterfoil of rent receipt dated 31/3/2011 for the month of March 2011. Exhibit 4 record calling petition of title suit number 133/2011. Exhibit 5 certified copy of the judgment of title suit number 130/2011 dated 18/1/2013. Exhibit 6 copy of the plaintiff of title suit number 133/2011.
No,
Exhibit 7
read para 6 of the judgment. From para 6.
Now coming to the main issue number 3, whether the defendant is a defaulter in the payment of rent. Learned counsel or the defendant tenant submits that there was no practice of tendering rent on monthly basis as mentioned in the agreement. DW1 has also stated that the plaintiff used to collect rent of 2-3 months together, time to time from the defendant by way of checks. Therefore, the plaintiff is not entitled to get the tenant and premises back on the ground of defaulter as asserted by the plaintiffs. The defendant has been depositing the rent in the court regularly when the landlord plaintiff refused to accept the rent for the month of April 2011. However, the PW1 is not duly authorized by the landlord/Hindu undivided family HUF. The terms and conditions of the agreement were both in practice between the parties, and the tenancy agreement itself is illegal. He further submits that there is no specific mention that the business of the plaintiff has been expanding and the suit premises is extremely necessary for the use and occupation. Therefore, the suit is liable to dismiss. After hearing the learned counsel of defendant tenant and going through the evidences available with the record, however, as submissions advanced by the learned counsel of the plaintiff, it is seen that the defendant has re-agitated some matters as to the creation of tenancy, increment of rent, sending notice of vacation, etc. All the facts have been already decided by court in title suit number 133 of 2011, which is apparent from the exhibit documents, exhibit 5 to exhibit 7. The agreement is not illegal. It is binding upon the parties accordingly. Moreover, as per clause 15 of the agreement, exhibit 1, the defendant tenant is bound to comply with the other clauses like clause 2 and 12 of the agreement, and for a breach of such condition clauses of the tenancy, the plaintiff landlord is definitely entitled to terminate the tenancy and also to vacate the tenant from the suit land. Going through the pleadings and evidence of the parties, it is also seen that 1, relationship of landlord and tenant; 2, creation of tenancy; 3, terms and conditions of tenancy; 4, increment in percentage in rent; and 5, termination clause of the tenancy. All these facts have been admitted by the defendant. It is also seen that PW1 is not outsider of the plaintiff HUF, and he is the son of the plaintiff number 2. The plaintiff number 2 is the Karta of the said HUF. Therefore, the authority letter is also not required. Moreover, PW1 has confirmed that he has personal knowledge about the subject matter of the suit during his cross-examination. Further, it is also seen that the PW1 has exhibited the authority letter as exhibit 10. Therefore, such submission with regard to the authority letter of the defendant side has no legal force. Now, the material facts in issue are to be seen whether the plaintiffs have been bona fide requirement, whether the defendant is a defaulter in paying the rent or not. So far, the fact of the defaulter is concerned, the plaintiffs have pleaded that the defendant did not make the payment of rent to them since 1/4/2011. The defendant has also not disputed in respect of non-payment of rent to the plaintiff since 1/4/2011. But he has been claiming that the plaintiffs have refused to accept the rent since 1/4/2011, and therefore he started depositing the rent in court. The defendant, in support of his contention of depositing rent in court, exhibited treasury challans and NJ cases records, exhibit A to exhibit E series. The clause 2 of the tenancy agreement contains that the rent for each month shall be payable in the first week to the following month as per English calendar months against written receipt from landlord. On the other hand, the defendant asserted that the rent for 2-3 months in together were deposited in the bank account of the plaintiffs earlier, and therefore the defendant claimed that the conditions of payment of rent for each month within first month of the following month did not remain in practice between the parties. However, the defendant has no proof that as per instruction and or wishes of the plaintiff landlord, he had deposited the rent for 2-3 months in together earlier, and plaintiff himself has allowed the defendant to pay the rent by way of check in such manner. Therefore, the defendant cannot claim that the terms and conditions with regard to payment of the rent for each subsequent month as per agreement in not in practice of force. So I am of the view that the defendant had been deposited the rent directly in the bank account of the plaintiff without any instruction from the plaintiff. This is also amount of violation of clause 2 of the agreement. Thus, I am of the opinion with learned counsel of the plaintiff that unilateral act of such depositing the rent does not amount to consent of plaintiffs, wherein a written specific contract is there containing specific condition payment of rent. Therefore, mere deposit of rent for few months in together and that too without any consent of the landlord cannot be said to be a waiver of such condition of payment of the rent. The plaintiff had denied that the defendant has not tendered the rent for the month of April 2011 and also not paid till date for subsequent months. Whereas the defendant claimed that the plaintiff had refused to receive the rent for the month of April 2011 when he offered it by way of check to the plaintiff. But the defendant did not exhibit the relevant check for the month of April 2011 in the case. Moreover, there is no explanation and assertions what prevented the defendant from making deposit of the month for the month of April 2011 or for the subsequent months in the saving accounts of the plaintiffs as earlier payment by way of checks. Thus, it is also amount to violation of clause 12 of the agreement. The defendant has no proof that he offered the rent for the month of April 2011 and for subsequent months prior to depositing the rent in court. Upon perusal of the cross-examination portion of the defendant DW1, it is seen that the defendant has admitted that he offered the rent for the month of April 2011 in the month of April itself, and the plaintiff refused to receive it. Therefore, as pointed out by the learned counsel of plaintiff, I am also the opinion that such offer, even if offer made by defendant tenant, the same cannot be considered as valid lawful offer of defendant. It is inasmuch as the rent for the month of April 2011 cannot be due in the month of April itself. So such offer is not an offer in the eye of law. Moreover, further, he admitted in his cross-examination that Exhibit B series NJ cases 2129 of 2011 does not contain the process fee, treasury challans and notices. In view of the said facts, also the deposit of the rent in court without compliance with the formality cannot be considered as valid deposit payment or rent. It is the burden of a tenant to prove the fact that he has been paying the rent regularly and allegation of the defaulter to get protection under Section 5 of the Assam Urban Area Rent Control Act 1972 from eviction of the tenanted premises. Besides that, Section 5 of the Assam Urban Area Rent Control Act also contains that along with the deposit of rent, the tenant is to comply with the conditions of submission of process fee, notices, as well as deposit of challans in the record, failing which the protection cannot be available to the tenant under the said section. Learned counsel on behalf of the plaintiff landlord submits that the bank deposit does not show that the plaintiff had refused to accept the rent. Thus, I am of the same view as submitted by learned counsel plaintiff. Such deposits, even therein, if they cannot be considered as valid deposit of the rent. The plaintiff side has cited the following case laws as to the claim that deposits of rent without complying with such mandatory formalities and cannot be considered valid deposit. The law is well settled as to once defaulter is always a defaulter. 2002 GLT page 75 Rupchand Bhattapuri versus Asim Razan. 1995 supplement 3 SCC page 44 Rameshwar Chaudhary versus Ram Niranjan Moore. 1997 2 JLR page 468 Abdul Mateen versus Nityananda. In the aforementioned case, mentioned case laws, it was held that without complying with the provisions of Section 5(4) of the Assam Urban Area Rent Control Act 1972 and depositing the rent in contrary to Section 5 of the Act, a tenant cannot claim to get protection from eviction. The law is that the protection is given to a tenant only if the tenant complies with certain requirements and obligations. As per subsection 5 of the Act, a tenant must deposit the rent money challan in the court together with process fees for service of notice upon the landlord. And on receiving such deposit, only the court should cause a notice of the receipt of such deposit to be served on the landlord. In the present suit, such formalities have not been complied in deposit the rent by the defendant tenant. Hence, it cannot give any protection to the tenant. Moreover, there must be evidences that the rent has been refused by the landlord and the tenant has offered the rent within a fortnight of his falling due. The depositing of rent in court comes only when a landlord refuses to accept the rent. Thus, it is seen that the mode of deposit of the rent in court includes submitting a proper court fees, challans, notices, etc., which are lacking in the present suit, and defendant has failed to prove all these facts. Hence, relying upon the aforementioned case laws, I am also of the view that the tenant defendant is defaulter as asserted by the plaintiff. Since the defendant has deposited the rent without compliance with the mandatory formalities, therefore he becomes, since in the month of April 2011, the law is well settled as to once defaulter is always a defaulter. Accordingly, I have come to a conclusion that the defendant has failed to prove this issue in his favor. This issue is decided in affirmative in the favor of the defendant tenant. Now coming to another main issue number 3, whether the suit premise is bona fide required by the plaintiffs for their own use and occupation. In the foregoing issue number 3, it is seen that the defendant is a defaulter. In the cross-examination, DW1 defendant has admitted that the plaintiffs have to keep their merchandise weighing machine on the veranda during the business hours and the said merchandise are to be taken back in the shop when it is closed. The defendant also admitted by using the word suitable space means the veranda of the shop, and he has no knowledge of availability of other space with the plaintiff except the veranda. As it is an admitted fact, therefore, further nothing more required to be proved. The plaintiffs have asserted that due to expansion of their business, the plaintiffs required more space to keep the merchandise. The averments made in the pleading of the plaintiff and exhibit documents, exhibit 1, 2, 8, and 9, exhibit 8 and 9 relate with the business and its expansion, and the said part of the expansion of the business of the plaintiff was not denied by the defendant. Rather, it was specifically admitted both in the written statement as well as in evidences. As per Section 58 of the Indian Evidence Act, thus further nothing more is required since facts admitted need not be proved. This proves that the business of plaintiff has been expanding and the plaintiffs have bona fide requirement in the respect of suit premises. In following cases, 1996 5 SSC page 353 Pratibha Devi versus TV Krishnan and 2001 SSC page 679 Raghavendra versus Firms Frame, it was held that the court should not deprive the landlord of the beneficial enjoyment of the property when there are bona fide requirements of their property for their personal use and occupation. Court should protect only honest and sincere tenant. Thus, with the efforts to discuss fact and reasons, I am of the view that there is an instant suit. The plaintiffs have succeeded to prove their bona fide requirement. Accordingly, the issue number 3 is decided in affirmative in favor of the plaintiffs. Lastly, coming to the finding of the issue number 4 and 5 together, whether the plaintiff is entitled to the relief is paid for and to
Okay,
what other
that is not required. No, this was upheld by the first appellate court.
Yes, sir.
Where it heard. Yes, Mr. Roy. This is a revision against
Lord.
dismissal of appeal.
Here, the pertinent question is whether a lady, widow lady, can act as a karta of a HUA. Because if your lordship will come to the plaintiff, your lordship, the lady represented as the karta of the HUA, that your lordship will get plain. Pay 27. 27 starts. Page 27, this is the plain lordship. Permit Kishori Lal Vijay Kumar, a Hindu undivided family represented by Srimati Kushum Kaur as Karta. So, entire suit has been contested by the Karta, Your Honor, who is a widow. Her husband name was Vijay Kumar Lordship. After his expiry, he left behind. Vijay Kumar left behind 2 sons. And 2 sons are still alive. And a lady cannot be a co-parsoner under the Hindu Mitakshara law, Your Honor. That Karta. So Karta, Your Honor, when the 2 sons as a co-parsoners of the HUP are alive, Your Lordship, the widow cannot act as a Karta of the HUP. In this respect, Lordship, the Supreme Court has settled the law, Your Honor, reported in.
You are on the ground that the suit was not maintainable.
Yes, it is not.
You took that plea before the appellate court.
Yes, yes, we have taken in WS also, we have taken this.
Okay.
The Lordship.
But no separate issue was.
No separate. And after amendment of the CPC,
No, then
Your
the-
Honor, it is the duty of the trial court to frame the issues, Lordship.
Then on the
This is
question of
and this is a pure question of law. This is a pure, whether a widow can be act as a karta of the HUF under the Mitakshara law. Answer is definitely no. Lordship, may please to peruse the apex court judgment. Lordship, may please to come to in para 18. This is the judgment of Your Honor, Lordship 2015-16 SCC, page 46. Parties are Shreya Vidyarthi versus Ashok Vidyarthi.
Para 18.
Para 18.
Yes.
While there can be no doubt that a Hindu widow is not a co-parsoner in the HUF, of her husband and therefore cannot act as karta of the HUF after the death of her husband. The two expression, that is the karta and manager, may be understood to be not synonymous, and the expression manager may be understood in denoting a role distinct from that of the karta. Hypothetically, we can take the case of the HUF where the male adult co-partner has died and there is no male co-partner surviving, or as in the facts of the present case where the sole male co-partner respondent plaintiff Ashok Vidyarthi is a minor. In such a situation, obviously, the HUF does not come to an end. The mother of the male co-partner can act as the legal guardian of the minor and also look after his role as the karta in her capacity of his minor legal guardian. Such a situation has been found, and in our opinion, rightly to be consistent with the law by the Calcutta High Court in so and so. Then in para 23, other Supreme Court judgment has been cited supporting my submission. Then I will also be pleased to the para 20, Lordship, the most relevant portion. Para 20. In the present case, Rama Vidyarthi was the stepmother of the respondent plaintiff Ashok Vidyarthi, who at the time of death of his father, Hari Shankar Vidyarthi, was a minor. The respondent plaintiff was the only surviving male co-partner after the death of Hari Shankar Vidyarthi. The materials on record indicate that the natural mother of Ashok Vidyarthi, Srimati Savitri Vidyarthi, had played a submissive role in the affairs of the joint family, and the stepmother Rama Vidyarthi, that is the second wife of Hari Shankar Vidyarthi, has played an active and dominant role in managing the said affairs. The aforesaid role of Rama Vidyarthi was not opposed to the natural mother Savitri Vidyarthi. Therefore, the same can very well be understood to be in her capacity as the stepmother of the respondent Ashok Vidyarthi, and thereafter consistent with the legal position which recognize a Hindu widow acting as the manager of the HUF in her capacity in the guardian of the sole surviving minor male co-partner. Such a role necessary has to be distinguished from that of a karta, which position the Hindu widow cannot assume by virtue of her disentitlement to a co-partner in the HUF of her husband. Regrettably, the position remains unaltered even after the amendment of the Hindu Succession Act in 2005. So, Lordship, in a Mitakshara Hindu law here, Lordship, a female cannot act as the karta of the HUF here, Lordship. And she is never treated as a widow, Lordship, never treated as one of the co-partners. In the present case, Lordship, when Vijay Kumar, the original owner, expired, he left behind me two sons. One son is an advocate, Lordship, and other son is also residing at Guwahati, your Lordship. So there were two co-partners. They had not joined in the plaint suit, Lordship. And solely, and the learned both the courts below did not look into this vital aspect and pass the impugned order in a perversity manner, Lordship, without considering the most vital question whether a widow can be treated as a co-partner under
the agreement was with HUF. The tenancy agreement
is there, Lordship. Lordship will
was signed by her as a karta, and it was accepted.
Whether legally it is admissible, your Lordship. Absolutely not. Because under the Mitakshara law, any widow cannot be, or any lady cannot be a co-person.
Whether you took this plea in your memo of appeal,
Appeal.
appeal before the first appellate
No,
court,
in my WS lordship, I have taken that plea.
then
So appeal is a continuation of the suit, lordship. Any appeal is a continuation of the suit. Revision is a continuation of the suit. There is no doubt about it. And this is a pure question, even if suppose lordship, for the sake of argument, that this plea was not taken. But there is a cause, issue whether the suit is maintainable or not. No finding has been given. So that is the perversity writ large on the face of the record. Because lordship, under the Mitaksara law, a lady cannot never treated, even after the amendment of the Hindu Succession Act in 2005, a lady cannot be treated. She will entitled to inherit equally along with the other co-partners, but she cannot act as a co-partner or even as the karta. So this one ground is sufficient to interfere, lordship, under section 115. Apart from that, lordship, my other submissions are that agreement of it. Regarding bona fide requirement, my lordship, the suit was decreed on two grounds, or the first defaulter and the second bona fide requirement. Now, your lordship, I have filed an additional affidavit, lordship. Lordship, put a question regarding the tenancy
where is the
agreement.
tenancy
That
agreement?
is exhibit, your lordship, in the trial court, your lordship will find. Trial court, sir.
C1.
61, no? One. Exhibit 1 is the agreement.
Trial court report. Huh? You have a copy.
Yes, I am having.
And the agreement was between
Agreement was between lordship Kushum
HUA.
Kumar, wife of Vijay Kumar, representing as the karta of Mr. Kishori Lal HUA. So agreement is on behalf of the HUA. He is not the karta, co-partner. She cannot act as a karta. So this agreement itself was void. Agreement 9, exhibit 19. Your lordship, peruse my.
We will continue at 2.
Lordship, in the second half, I am having some Vijay Mohan Bhagwat, chief of RSS is coming. There is a meeting. I am also one of the
That
invitees.
is at 4 PM, my lord. So for
No,
1
no,
hour, it will be completed.
It will take not less than 1.5 hours to reach in lordship VIP, crossing Hengravari.
Okay,
RSS
then let us fix it on some other day.
It will remain as part heard.
At 3 he will move. He told me that at 3 he
No,
will.
let us not put him in so much trouble. Let him attend the meeting. Heard, Mr. SP, we will not keep it parted because only this bench is taking up civil dossier. We will take it upon.
My learned friend will get an opportunity to counter my submission regarding achievement.
Suggest a date.
This week, my lord, if possible.
Next week,
Because
Thursday.
On 20th, I will be.
27.
28th, I will be, I will go to outside, my lord.
27.
So 27 is some other case, my lord. So it may be on 26.
26, no, my many cases are.
26 or 25.
2nd of December.
25.
Heard,
Second
Min-
of December.
I will not be there, my lord. I will come after Bihu, my lord.
Then let us keep it after Bihu.
Very long adjournment. If it is fixed on 25 or 26 at any date, my lord.
Suggest Mr. Roy.
27, I am ready. 26, I have many cases.
27 already a fixed case is there. It is parted, my lord. I will.
Let us see on that day.
Huh?
Let us see. You address the legal point raised by the plaintiffs.
Yes,
appellant's counsel.
on 26 or 25, my lord.
26.
Yes.
20,
25, then 25. 26, I am having many cases.
Heard Mr. S.P. Roy, learned counsel for the appellant, learned counsel for the petitioner. Also heard Mr. J. Sharma, learned counsel for the respondent. The hearing remained inconclusive. List this matter again on 25th of,
As part of my lord, may remain as part.
not necessary. It will otherwise come to this bench.
Because my lord, otherwise it may not reach again then. It may keep a part of my lord, because some hearing was done, my lord, from the side of the petitioner.
As part of matter
Yes.
on 25. Yes, Mr.
Item 5, the respondent number 2 and 3, I am representing. I'm sorry, Lordship, at the time of calling, it was recorded as non-appears.
Item 5.
5.
Respondent number 2 and 3 show the presence of Miss R. Chaudhary. For respondent number 2 and 3.
For respondents, Lordship.
My lord, there are two matters shown, my lord, tagged together, my lord. But I am only for, my lord, AB number 1692, my lord. Not for, this is different advocate, my lord, 1484, my lord. I want to withdraw in respect of, my lord, AB number 1692, my lord.
Item number 1. Item number 1, AB number 1692. Guta item ase. Only ata item atwandu. Heard Mr. S.M. Mullah, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal. Stop. Next item, AB order Koribo. This item was tagged with item number.
Same item number.
This anticipatory bail application was tagged with anticipatory bail application number 1692/2023-25, which was withdrawn by the petitioner. However, as no such prayer was made in the instant bail application, list it in its due course before the appropriate bench.
That was AB number 1484, my lord.
Second one.
Second one. Obliged.
Item number 8.
Here, my lord, with all respect, my lord. Only the application has been filed, my lord, with all respect, my lord. Earlier rejected, my lord, but it has come to our notice now that, my lord, section 48 has not been complied with, my lord. And straight away, can I come to, my lord, with all respect, my lord? 20, page 29. First of all,
where is the earlier rejection order?
May you come to page 48, my lord. Of course, my lord.
47 was ours. Page 52.
Page 52, para 18, my lord.
47 was ours, 48 was ours.
48 was not ours, my lord. 47 was ours. The plea of 47 violation was taken, 48 was not taken, my lord.
Okay, can you take it now?
So that, my lord, I can, because constitutional right violation, my lord, I can take it at any point. That Babu Singh, my lord. Lordship, it has been reflected in many authorities of your lordship, this High Court, my lord. When it comes to, my lord, as because it is a violation of constitutional right as well as statutory, consequential statutory right, my lord. When it comes to the notice of the accused, my lord, he can raise it at any point of time, my lord. That's the on that there.
What authority you are relying? One single authority.
Apex Court, my lord. Yes, my lord.
Yes.
Lordship has quoted it many number of times, my lord. This High Court has quoted many number of times. Can I just?
Okay, let him see and you come to the merit.
Here, my lord.
Page 29.
Page 29 is the final complaint. First of all, he is there for 1 year, 2 months, my lord. Final complaint, my lord, page 29.
Yes.
This, my lord, and so far as 48 violation is concerned, my lord, of course, my lord, they are customs, my lord. The same, my lord, DNSS applies, my lord. But they do not write notice under section 47, 48. Those, my lord, possibly there has to be a direction someday, my lord. Here, my lord, in the 48 paper that was served on us, my lord, that occurs at page, my lord, 59, my lord. 59, my lord.
Yes.
59, my lord. Last part, my lord. It has been served to one Sondrodhar Das, and I'll place the factual matrix, my lord. Some other persons were there, they did not serve it. Why, I do not know. Regarding Sondrodhar Das, it was sent in this manner, my lord. Starting last lines, my lord. Last 3 lines. Lordship may have found, my lord.
Yes.
It is also to inform that, as provided by Bipul Kumar Das, that they are meaning thereby, the number was taken from Bipul Das, the accused who is seeking bail. This office has intimated you, meaning by Sondrodhar Das, you, at your number so and so about his arrest. So Vihan has been violated, it is not in writing, and thereafter another authority of the apex court that I'll place, my lord. So it was sent by telephonic message, not even WhatsApp,
But this notice has been sent,
my lord.
notice at 59. Who is
Yes.
Chandradhar Das?
Brother-in-law, my lord.
Brother-in-law. This is the notice under 48.
Exactly, but they do not write 47, 48. They said,
No, let us assume it to be 48
"Hey, it is
notice.
48, not assume, my lord, it is 48,
Then it contains, where is your,
my lord.
how it has violated?
It has not been signed, not received by nobody, my lord. 48, relative, friend or a person authorized, not received, my lord. Only a telephonic message was sent. Whether over phone,
No, how this notice was sent?
my lord.
You have not received this notice.
Nobody has received this. Sondrodhar Das has never received this notice, my lord. Only it was not signed, my lord. This is the notice, my lord. It was only sent by,
Now, how it will be signed? It will be signed sent either by post or some other means.
or by a personal, when the man is present, my lord. Kindly see the factual matrix. Here, my lord, this is the notice. Let me, my lord, digress a little, my lord. Lordship may come to a Ghonik the present. Notice was served on the accused on 5th. He appeared on 5th along with his wife. That is apparent at page 29, my lord. Page 29. Para 18.
Yes.
There it reached, my lord, that sir, the panchas along with custom officers opened the lock of the room where the seized goods were stored in their presence the previous night. In the meantime, Bipul Kumar Das, the accused, my lord, the owner and possessor of seized good and also his wife, Sapna Das, had reached the custom. Sapna Das was present. The notice under 48 should have been issued to her. She was present, may have been issued. Raised the customs office as they were summoned to appear before the superintendent customs so and so. And why I am stating this summon was served on the accused and thereafter he was arrested and he appeared along with his wife. Instead of giving it to his wife, it was sent to one character, relative, definitely relative, not personally, individually or otherwise, my lord, over telephone. And this is apparent. WhatsApp never sent, my lord, only telephonically. They say. And secondly, my lord, with all respect,
How that, what is the claim of the customs? How they have sent that notice?
it is the notice itself, my lord. There is no other document. this notice either has to be signed by Chandradhar Das, to whom it is sent.
Or there has to be something to show that how this notice was sent.
They stated, my lord, in their, it is
That is
also,
in addition to sending.
that is their language, my lord. But this is the notice, we have annexed, no sign. There is to be a signature upon being received, because that 48 format, but unfortunately, they don't use the 48 format. They are above BNS. That's besides the point. Here, my lord, this notice, Chandradhar Das never received, and I was prejudiced because on the date of production, date order also I have annexed. I never moved any bail application. I was no advocate. How can it happen, my lord? This Chandradhar Das, that he received this is a certified copy, my lord. There is no signature of Chandradhar Das, my lord.
Who is Chandradhar Das?
He is the brother-in-law, my lord. Despite his wife being present, it could easily have been served on the wife. They both voluntarily appear.
And you are denying that brother-in-law has not received
No, no,
this?
no, brother-in-law is my brother-in-law, my lord.
No, yeah, brother-in-law has not received this notice.
Signature is not, they are not received, my lord.
You are
That's why-
denying it.
No, no, because that's
You
a
are
factual,
denying receipt of this
that's
notice.
a factual matrix, my lord.
Okay.
Had he received, he would have informed me, or he would have engaged a lawyer, because I was in jail, I could not,
So
despite
burden
receiving.
is on them to show how
Well-
it was served.
Yeah, yes, yes. They, my lord, I have understood. Yes, ma'am.
Yes, Ms. Dekar.
Lordship, here, Lordship, final complaint filed on 28/2/25, Lordship. Charges frame on 25/4/25. Lordship, here, Lordship, case is at the initial stage, Lordship, and regarding there, our Lordship,
No,
I-
their only plea is that you have not complied with 48.
regarding 48, how they send notice, in this regard, I have not received any instruction, how they send Lordship 48
They
notice.
took 3 days for
Lordship.
instructions.
But Lordship, at the time of his arrest, his wife was there, Lordship.
But you have not served notice on his wife. That is one of their submission. That though wife, their main contention is that 48 notice is mandatory. You could have served that on his wife. Or you have to show how you have sent this notice. Initial
57.
H.
So I have not received any instruction in this regard, Lordship, how they have sent notice.
And what is your submission?
3 days time to obtain instruction.
No, no, but 3 days for this instruction, kindly see, Lordship, kindly have a look at page 54. We have planned with clean hands, my lord. 54. This is the summon to Vipul Das prior to his arrest, dated 4/9. And he was directed
No,
to a,
let me give 3 days time.
my lord.
Let them show.
But,
Because
my lord,
that is your main contention.
yeah.
Heard Mr. B.K. Mahajan, learned counsel for the petitioner. Also heard Ms. M. Dale, learned additional public, learned counsel for Customs Department. This application under section 483 of BNSS has been filed by the petitioner, namely Vipul Kumar Das, alias Vipul Das, for the second time, seeking his bail in connection with. Charge sheet has been laid.
Yes, my lord.
What is the NDPS case number?
My lord, NDPS case number
In connection with
59/25.
NDPS case number 59/2025, pending before the court of learned. Which court?
My lord, page 2. My lord, Kamru, my lord, Court of Additional District and Session Judge, FTC number 3.
FTC number 3. Prior to approaching this court by filing the instant bail application, the petitioner had approached on an earlier occasion by filing bail application number 2058/2025, which was dismissed by this court on by order dated 26/8/2025. learned counsel for the petitioner has submitted that the main contention of the petitioner in approaching again seeking bail in this case is that at the time of his arrest, the mandatory constitutional requirement of serving notice under section 48 of BNSS to the friend slash relative slash nominated person of the petitioner was not complied with. He submits that though the Customs Department has relied on a notice dated 5/9/2024, purported to be a notice under section 48 of BNSS, which was issued to one Chandradhar Das, who is the brother-in-law of the present petitioner. However, said notice was never received by the brother-in-law of the petitioner. He submits that neither the said notice contains the signature of the addressee, that is within brackets Sri Chandradhar Das, to acknowledge the receipt of the said notice, nor the Customs Department have shown as to how the aforesaid notice was served on the said person. On this, the learned counsel for customs
Also,
seeks some time to get proper instructions and place the details before this court regarding the mode in which the purported notice under section 48 of BNSS dated 5/9/2024 was served on the brother-in-law of the present petitioner, namely Sri Chandradhar Das. The prayer is allowed. How much time?
Friday.
Friday.
Let this matter be listed again on 21st.
Only just academic, my lord. Lordship, kindly have a look at page 33. No, let it remain Friday, my lord. 33, my lord. May I kindly have a look, my lord. Their paper, my lord. Para 34. Page 33. Para 34. Lordship, may have found, my lord.
Yes.
There, my lord. Hence, the accused person was arrested on 5/9/24 under section 42 of the NDPS Act 85, and the grounds of arrest were communicated to them. He was allowed to call over phone to his family, informing about his arrest. Thereafter, copy of arrest memo along with firm impression, personal data, and financial profile of the accused person, so and so, and his declaration about passing information of his arrest to his family members through phone call. That it is not their case that they serve notice,
okay.
apparent on.
You also address this court as to whether mere telephonic call to the
There is an authority, my lord, latest.
is enough to comply with the 48 notice. On the next date.
My lord.
Yes.
May I please? Your Lordship has passed an order in criminal petition number 1294. There are some typographical mistakes in the order as well as in our petition also. Well, in a IA application in paragraph 2, I have said the first typographical mistakes are instead of Sanjoy Pal alias Gatu Pal, the name of the petitioner number 4 should be Sanjoy Pal alias Khata Pal. Sanjoy Pal or Khata Pal was 5 days, Sanjoy Khata Pal, it should be Sanjoy Pal alias Khatu Pal, Ghattu Khatu Pal. This is the first. And secondly, my lord, the second mistake, actually it was in our petition's mistake. The petitioner number 9, the name is typed as Niranjan Shah. Actual name is Niranjan Shah, but in the accused person's list, in the search sheet, his name is written as Mona Saha. In fact, his nickname is Mona Saha. So it should be Niranjan Shah alias Mona Saha.
These two mistakes.
It is second mistake. And
How many mistakes are there?
5 mistakes.
Then we'll dismiss this.
Five
These mistakes were in the petition itself.
Or not
Then-
only petition itself, all in order also.
Order because you mentioned wrongly in your petition. How order can go beyond the names?
Yes, my lord.
You mentioned wrong names in your petition.
Name is Niranjan Shah. It is second name is Niranjan Shah. It is okay. It is actual name.
What is the third mistake?
Third mistake is the father's name of the petitioner number 11. Suiten Das. It is typed as Subol. Actual name is Suiten Das. Father's name. This is third, my lord.
Yes.
And in the fourth, in the order, the word rioting is typed as writing, my lord. In the second line of the third paragraph. In the order it is.
Yes.
In our petition, my lord. And fifth is actually in some orders it was mentioned as judicial magistrate first in post title we have mentioned as judicial magistrate first class perpetua. It is correct, my lord. But interior in prayer we typed as additional chief judicial magistrate board. Actually, in fact, the trial was first tried at the additional CJM Borpeta, but later on it was transferred to the judicial magistrate first class Borpeta. Yes, all this. In place of additional chief judicial magistrate, it should be judicial magistrate first class.
Heard Mr. G. Pathak, learned counsel for the applicant. who For the presence of additional PP also. This interlocutory application has been filed by the petitioners in connection with criminal petition number 1354/2025.
1-9.
13. Again, you have committed mistake. We'll dismiss this.
No, sorry. 1-5.
What is the number?
One to 9.
Then you have in your interlocutory application.
1-9.
Yeah.
In order 1-9 for my lord. And interlocutory application it is also 1-9.
You come to your,
But interlocutory application number is 1-5-4. But in criminal petition number is 1-3-9-4.
which one is the correct?
Interlocutory application number is 1-5-4, my lord.
You come to page number 2 of your interlocutory application. Page number 2.
Page number 2.
Page number 2. What is the number of criminal petition which you have mentioned?
Sorry, my lord. It is again.
It is because of your fault we are losing judicial time. You are
Sorry, my lord.
very casual.
So I have given the typist.
की लिखिले 1394/2024 praying for rectification of certain inadvertent typographical mistake which has crept in the order as same typographical mistakes were there in the criminal petitions also. He submits that in the order dated 14/11/2025, as well as in the criminal petition filed by the, no, he submits that in the criminal petition filed by the criminal petition number 1394/2024, as well as order dated 14/11/2025, was therein the name of the petitioner number 4 has been wrongly typed as Sanjay Paul alias Ghata Paul, whereas it ought to have been Sanjay Paul alias Ghatu Paul, Ghatu, Ghatu Paul. He further submits that similarly, name of the petitioner number 9 has only been reflected as Shri Niranjan Saha, whereas it should have been reflected as Shri Niranjan Saha alias Shri Mono Saha, Mona Saha, M-O-N-A. He further submits that the name of the father of the petitioner number 11, Shri Sanjay Das, has been wrongly mentioned as Subal Das, whereas it should have been Satyen Das. He also submits that in paragraph number 3 of the said order, in line number 2, instead of the word rioting, R-I-O-T-I-N-G, the word writing has been mistakenly typed out. Same needs to be rectified. Stop. I have gone through the I have gone through the records of criminal petition number 1394/2025, as well as the impugn order. The errors pointed out by the learned counsel for the applicant appears to be inadvertent typographical mistakes, which needs to be rectified. Accordingly, same is done.
My lord, another
Judicial magistrate, that is not necessary.
style.
It is pending in the court of judicial magistrate
Judicial
first.
magistrate, formally it was before the petition as well. Now it is before the judicial magistrate.
No, you are directed to appear before.
Before the trial court,
See,
my lord.
That mistake is not need to be corrected. Accordingly, same is rectified. The name of the petitioner number 4 in the order dated 14/11/2025 in criminal petition number 1394 shall be read as Sanjay Pal alias Ghatu Pal instead of Sanjay Pal alias Ghata Pal. Similarly, name of the petitioner numbers 9 shall be read as Niranjan Saha alias Mona Saha. Similarly, the father's name of petitioner number 11 shall be read as Satyen Das instead of Subal Das. Stop. Further, in paragraph number 3 of the aforesaid order, the word writing, WRITNG, appearing in line number 2 shall be read as rioting. With above observations, this interlocutory application is disposed of. Yes.
May please also. Not this petition, my lord. This more of a my lord petition seeking some mercy. Why, my lord? The petitioners filed as plaintiffs, they filed a suit. Against that, my lord, the defendants filed written statement along with counterclaim. Thereafter, my lord, when we could not file,
Suit for what?
suit for my declaration, simpliciter, my lord. So when, my lord, we could not file a written statement against their counterclaim, my lord, we made a prayer seeking some time. That prayer was rejected. Subsequently, again, we made a prayer. That prayer was also rejected.
Why it should be allowed now?
Yes. So the facts are like this, my lord.
Where is the impugn order?
Impugn order, my lord, there are two impugn orders, man. And just state the facts. My lord, one, Romanikanta Bhattacharjee, he had 4 sons. Randhir, Ranjit, Ranabir, and Bidhan. So plaintiffs, my lord, are the legal heirs of Ranabir.
Okay.
So our case was that Ranabir and the other son, Ranjit, they purchased the suit land by way of a sale deed. And in that suit land, my lord, the other brothers were also allowed to remain as permissive possessors. So thereafter, my lord, when we asked them to leave, when they did not leave, so we filed this suit, praying for declaration of our right title interest and recovery. Against that, defendants filed counterclaim, my lord, saying that the sale deed was executed by Ranadhir and Ranjit, not Ranabir. The defendants are the legal heirs of Ranadhir. So they filed their counterclaim. Now, Lordship will kindly see page number 99. 99, that was the first petition which we filed on 26/9/2023. 26/9/2023, praying for some time for allowing us to file our written statement against their counter.
That was beyond the 90 days.
Yes,
Your petition was beyond 90 days.
yes. So it was rejected. Rejected, my lord, by an order on 26/9/23 itself. The order, my lord, is at page number 100. Thereafter, my lord, again, we filed a second petition, my lord. This time it was filed on 16/11/2023. Saying that, my lord, the plaintiff number 1, who was the wife of Ranabir, she was a cancer patient, and all the petitioners, all the plaintiffs were busy with her treatment. So they could not take steps, and that is why they required some further time. So that petition was also rejected. This rejection order is a page number 105, 16/11/2023.
Yes.
Now, my lord, the law regarding, my lord, the time for filing written statement is not fixed, like that is in case of a regular suit. In counterclaim, my lord, if your lordship will see, order 8 rule 6A, it says, my lord, the plaintiffs will be at liberty to file the written statement against their counterclaim at such time which will be fixed by the court. So there is no specific time limit.
So 90 days rule is not
No, no.
applicable.
And that will have to be read with section 148. 148 says that if any time is fixed by the court, then after that, beyond that, the court can extend, but not, that should also not be more than 30 days. As per 148. So I am not on the technical base, my lord. I simply want my written statement to come on record. Since, my lord, the trial has already partially started. Tomorrow is fixed for cross-examination of PWs. So before that,
PWs.
yes, before that, if we can bring the written statement on record, that will help. Otherwise also, my lord, in case of a regular suit also,
But you have to show valid reasons for
Yes.
your default.
in case of a regular suit also, that period of 90 days is not mandatory, it's directory. In case of commercial suit, it is mandatory. In case of normal
No,
suit,
it is directory,
yes,
but to get
exceptional
the,
situation. This is perhaps a situation, my lord, which was exceptional for the family because they were all busy with the treatment of their mother and the medical documents I have annexed, my lord.
where is the second first impugn order?
Second, my lord, is the page number 105.
Where is the?
First,
Who is suffering from cancer?
the wife of Ronobir, that is the plaintiff.
Plaintiff number one.
Plaintiff number. So considering that exceptional situation, perhaps if otherwise, my lord, the pleadings are competent, my lord, only thing is that the
You
written
have to pay the costs.
Yes, we will pay, my lord.
How
We are ready.
much?
As your lordship deems fit, my lord, we are ready to pay. The only thing is that our written statement may be on record, that much.
What are the stakes?
Because,
What is at stake?
my lord, what they have said, that
How much you suggest a quantum?
that I'll leave it to your lordship.
Pay 5,000.
My lord.
Okay, subject to your payment of 5,000. The pity. I'm not issuing notice to
Right.
the other side. And write orders in chambers. There is.
Highly obliged.
When will you submit your WS?
But we will submit tomorrow, my lord, before the trial court, my lord, since the next date is fixed tomorrow.
Okay, tomorrow.
Highly obliged.
Disperse.
Item 6.
Yes, Mr. Nawaz.
The lordship is pleased to appoint me as amicus in the matter. In the last date, the petitioner is appearing in person in this case.
Yes. She has challenged
It's one of the
the,
order.
does she have merit in her case?
The lordship can see the order, madam, page 199. The matter pertains to probate of a will. And on 31/7/2025, after both the parties filed their draft issues, the court has framed the issues and fixed the case for evidence of the plaintiff. And the issues the lordship will find at page 200. Those, my lord, whether the probate title suit is barred by limitation, whether the document put forward by the last will and testament dated so and so was duly executed and attested in accordance with law, and whether at the time of such execution, the testator had sound disposing mind, because the respondent side had taken up a plea in their WS that the person was suffering from dementia. So now, one thing which I have seen is that the petitioner basically has two grievances. First is that, my lord, all the issues which were projected by the parties by filing the draft issues were not taken up by the learned trial court. And the second is that the defendant had not filed the mandatory documents. That is the petitioner's basic case. My lord. Now, as far as the suit for probate is concerned, my lord, because at the end of the day, the court is only going to decide if the will was properly executed or not, whether the executor had sufficient faculties of mind. So those issues are there. Now, the petitioner contends that there are other additional issues which required to be taken up by the trial court. Now, in that regard, my humble submission is about Order 14, Rule 5. Is a specific provision under which the issues can be amended or additional issues can be framed. So if there are additional issues which require to be agitated before the learned trial court, my lord, in that case, the petitioner would have the liberty or the right to file an appropriate application under Order 14, Rule 5. Then the trial court can adjudicate those issues as to whether those issues.
What issues were not framed?
Petitioner has projected multiple issues, including the the legitimacy of the petitioner will be able to better highlight before this honorable court, because I have not found the draft issues here in this petition, my lord. And the issue regarding the legitimacy of the child and the property in question. Actually, my lord, those are issues which, if the case goes for a letters of administration case, my lord, there they would otherwise be pertinent. But in any case, my lord, my humble submission is that your lordship may not decide that aspect, whether those issues are essential or not. The lordship is basically deciding whether this order suffers from a perversity or not. Since the liberty is available before the petitioner, let the petitioner go and file those applications before the learned trial court. Trial court may decide and both parties can be heard. And if there is any merit in the petition, court can decide that petition. But for that, my lord, CRP, my lord, that
If thereafter she is aggrieved,
then
she may.
she can come and project that these issues are vital. But at this stage, perhaps it will not be necessary for this honorable court to decide whether those issues are relevant or not at this stage before this honorable court. Because your lordship is only examining the perversity of the order.
Yes.
At the end of the day, what issues is to be framed, that is the prerogative of the trial court. So that is one aspect, my lord. And the second aspect is regarding, my lord, furnishing of mandatory documents. So your lordship will see, again, I'll request your lordship to kindly come to page 197. This was the previous order. So both parties had filed their own pleadings, and that another petition was filed, which was treated to be replication. Basically, that's a rejoinder, my lord, to the WS of the defendants. And thereafter, my lord, in page 198, the learned trial court fixed the case for issues and documents. So on the next day, the issues were framed. So the petitioner's contention is that on that day, the defendant had not filed any documents, and that is not reflected in the order. So in that context, my lord, otherwise, the law is that Order 8, Rule 4, Rule 1A, my lord, the documents which are to be furnished by the parties, the documents which the parties rely upon, defendant relies upon, those have to be furnished. And before settlement of the issues, original documents, if the parties are relying on the original documents, those have to be furnished. Now, another Rule 3 is that if they do not furnish, subsequently at a later stage, if they want, then it can only be permitted with the leave of the court. That is the law, my lord. So now, one thing which the petitioner, talk to the petitioner's grievance is that this is not reflected in the order, that the defendant has not filed any documents. That perhaps an observation can be made. Otherwise, it is not required, my lord, because had they filed,
it would have been reflected.
It is not there, so that in a way that means that it has not been filed. But an observation.
We can make an observation here that if later on, if the defendant wishes to file it, the bar under Order 8, Rule 3 would be applicable. And she may oppose to admission of such documents, that it was not filed at appropriate time.
Appropriate time, before settlement of issues.
Clear? Anything you want to say? Okay. Yes, Mr. Bhagwati.
So, lordship has the other day already.
No, amicus has not said anything which is contrary to yourself.
Lordship court has directly understood that it is not an impugn order. Under challenge, it is not an impugn order.
No, he has only submitted there is no infirmity in the impugn order. And the petitioner would have ample opportunity of filing an order, application under Order 8 Rule 5,
Order 14.
Order 14 Rule 5 for framing additional issues. Then if a cause of action arises, then now it is premature.
Yes. Only thing in a probate case, the only one issue is there, whether the probate was duly executed or
No,
not.
that you can plead before the trial court. And regarding documents, you have,
Documents, we don't, it is their case. Documents, if we do not file, it will fail.
okay. Third, Ms. Sanchita Roy Chaudhary, the petitioner appearing in person, as well as Mr. Sarfraz Nawaz, the amicus curiae appointed by this court to assist this court. Also heard Mr. B.K. Bhagavati, learned counsel for the respondent. This application under what provision?
227 of the Constitution.
Under Article 227 of the
Constitution.
Constitution of India has been filed by the petitioner in person, Ms. Sanchita Roy Chaudhary, who has filed the probate title suit number 11/2024 before the Court of Learned Additional District Judge number 1, Kamrup Metro. Oh, okay. Okay. And presently pending as probate title suit number 11/2024. The petitioner is aggrieved with the order dated 31/7/2025, by which the trial court has framed three issues as follows. And court issues from page number 200. She is further aggrieved. She is mainly aggrieved on the fact that though in the draft issues submitted by the parties, some more issues were proposed, and though contentions to that effect were also made in their respective pleadings. However, said issues were not framed. For example, said issues were not framed. Said issues were not framed. Learned counsel for the learned amicus curiae for the learned amicus curiae, Mr. Sarfraz Nawaz has fairly submitted that on perusal of the memorandum of issues framed by the memorandum of issues dated 31/7/2025, in which issues framed by the trial court are reflected, it appears that necessary issues which are required for deciding a probate title suit appears to have been framed. He, however, submits that even after that, if the petitioner has some grievance, she may very well approach the trial court by filing an application under Order 14 Rule 5 for framing of the additional issues. It is only after she approaches the trial court and decision is made thereon, she might have a cause of action in approaching this court. He further submits that the other grievance of the petitioner in person is that though as per Order 8, Rule 1A, it was incumbent upon the respondent to submit the documents submits the documents on which the respondents were relying for their defense before in the private tribal title suit. However, they submitted no such documents, and there is no reflection to that effect in the impugn order dated 31/7/2025. He further fairly submits that since the order dated order dated 31/7/2025 does not mention about any documents submitted by the defendant side. It is apparent that no such document was submitted. He further submits that otherwise also the law is such as if now the defendant intend to submit any documents in their defense, they cannot do so without seeking leave of the court under Order 8 Rule
1A sub Rule 3.
1A within bracket 3. And an objection to that effect may be taken by the petitioner in the said probate title suit. Learned counsel for the respondent, Mr. B.K. Bhagwati, on the other hand, submits that there is this revision petition under Article 227 is not maintainable inasmuch as the impugn order, the trial court has framed all relevant issues, and he agrees entirely with the submissions made by learned amicus curiae. Stop. The petitioner in person is also agreeable to the suggestions made by learned amicus curiae. In view of the above, this civil revision petition is disposed of with an observation that if the petitioner is aggrieved with non-framing of certain additional issues which she thinks were required to be framed on the basis of the pleadings of the parties, she may approach the trial court by filing an application under Order 8 Rule, Order 14 Rule 5. If she desires to do so. Moreover, as apparently no documents were filed by the respondent along with their written statement, they would be precluded from depositing any such document without the leave of the court in terms of the provision under Order 8 Rule 1A within bracket 3 of the Code of Civil Procedure. And in such a case, the petitioner would have all right to object to such admission of such documents. With above observation, this CRPIO is disposed of. This court appreciates the assistance rendered by learned amicus curiae in this case.
Mid-page.
Yes.
We have instituted this second appeal against the decree of reversal dated.
In the earlier case, madam, there was a stay order. It was obtained by the court.
Yes, in consequential upon disposal of this case, the stay order granted earlier stands vacated.
Lordship, this appeal is against a decree of reversal dated 6/6/2025, passed by the learned ADJ Tinsukia. Now our substantial questions of law is at page 8 of the memo of appeal.
Page
8. I'll read the second one first. Whether the appellate court was justified to dismiss the claim of the appellants in view of the law of limitation, in as much as the cause of action was continuously subsisting up to May 2006. And number one, whether the learned appellate court was correct in holding that the entire suit has been rendered invalid due to non-joinder of necessary parties, specifically in view of the fact that the contract was between the appellants and the respondents, which was unilaterally terminated.
That would be a question of fact only.
But there is a question of law because the contract was between me, I am the plaintiff, and the ONGC, who is the defendant. So the contract was that I'll give my vehicle for hire and reward, and they have accepted that. And during the course of the contract,
Who were considered as necessary party by the trial?
the army and the DC, deputy commissioner.
So you're pleased that they were not necessary.
They are not necessary parties because my contract was.
So whether they are necessary parties or not,
Yes.
to find out that, we will have to go into question of facts.
Yes, but there is this thing called law of bailment also. So in view of that, both the parties are bound by the law of contract. So I'll take your lordship to section 148 of the Contract Act.
No,
Yes.
what trial court did?
Trial court, the first court has allowed has decreed the suit in my favor, which your lordship will find at page 36, your lordship will find the first court's finding. Learned civil judge. I'll read from para 13, page 36.
Page 36
Of the memo of appeal, para 13.
pagination is very. In page 36, there is no para 13. Page 36 is the appendix. Yes. Hence,
From
page
the
34.
34. I'll read that para. Hence from the above evidence, it is proved that though the defendants released the vehicle via exhibit B1 and E1 but the DC Tinsukia did not release the vehicle as written in the exhibits. There was no written contract after 15/5/2002 between the defendants and the plaintiff, but the vehicle bearing number is so and so was not released and was used as per the contract. The letter.
Ultimately, appellate court dismissed your suit.
Ultimately.
You are
appellate court
objecting,
dismissed
or let us frame the issues.
on the ground of non-joinder of necessary party, and my suit was barred by limitation. On these two specific grounds, the appellate court.
But the
has
contract was expired, Lordship, on 15/4, there are from 15/4 to 15/5/2022, there is no contract.
Yes, but
Between
the
the
problem
IOCL
is-
as well as the plaintiff.
Problem is that letter that specifically says that the contract, they have terminated the contract. But whether the vehicle was returned, that is the prime question. Without returning my vehicle, the contract couldn't have been expired. And the contract still subsisted up to May 2006, when the army has released the vehicle, has de-requisitioned the vehicle and returned the vehicle to me. So the continuous wrong committed extended up to May 2006. So if we count 3 years from May 2006, my suit is not barred by limitation. So that thing, the learned appellate court has misjudged.
The requisition vehicle was released on
On 15/5/2002,
15/5.
2006. 15/5/2006.
Okay, heard Mr. S. Datta, learned counsel for the appellant. Also heard Mr. What is the name?
K. Kolita.
K. Kolita,
For all the respondents.
learned counsel appearing for all the respondents. This regular second appeal as under section 100 of the CPC Code of Civil Procedure 1908 has been filed by the appellant Messrs. Mahadev Traders, impugning the judgment and decree dated 6/6/2025 passed by the Court of London Additional District Judge Tinsukia in Money Appeal number 1/2023, whereby it reversed the judgment and decree dated
23/12.
23/12/2014 passed by the
Civil judge.
passed by this learned civil judge, civil judge Tinsukia, whereby the money suit filed by the present appellant, that is money suit number 7/2008 was decreed in favor of the present appellant. By the impugned judgment, the first appellate court allowed the appeal of the respondents, allowed the appeal filed by the present respondents and dismissed the claim of the present appellant. After considering the materials available on record and after, as well as submissions made by learned counsel for both sides, following substantial question of law are formulated in this case. Whether the first appellate court came to a perverse finding that the claim of the appellant / plaintiff was barred by law of limitation inasmuch as the truck hired by the it was truck.
It was an ambassador car.
and the vehicle hired by the respondent authority was released only on 15/5/20, 15/3/20,
It will be 24/5/2006. Exhibit 20.
24/5/2006. And therefore, the period of limitation in filing the, and therefore whether the period of limitation for filing the money suit by the present applicant would run only from May 2006, only from the said date, contrary to what has been held by the First Appellate Court. Number 2, whether the First Appellate Court, whether the finding of the First Appellate Court regarding the fact, and to the effect, finding of the First Appellate Court, to the effect that the claim of the present appellant in money suit number 7/2008 was bad for non-joinder of necessary party is perverse. Issue notice to the respondent since the Mr. K. Kolita has already appeared on behalf of all the respondents. No formal notice need to be issued to the respondent authority, respondents. Let the records of the trial court as well as First Appellate Court be requisitioned from the concerned courts. Let this matter be listed after 4 weeks on receipt of the aforesaid records. Respondent is not there. It is to be done.
The case of reversal. There's money suit was initiated by the plaintiff, that is me, lordship, and it was decreed in my favor. Thereafter, they have gone for appeal.
Is it proceeding ex parte? No.
No,
Who is appearing?
see upon the cause list it has shown.
What is your submission? You can either submit to proceed ex parte.
Informing that GC consent has expired.
Then what should we do? Issue notice to the who is the respondent in this case? Only one counsel has been engaged.
Cause list. Lordship will give a short date, we may inquire about it. If we
You,
get any information.
you inquire. I am not reflecting anything. We inquire. Heard Miss
That's totally.
Astro D. Learned Counsel for the appellant. No one has appeared for the respondent, though the name of Mr. G. C. Fukan has been reflected as engaged counsel for the respondent in the cause list. Considering the circumstances, this court is inclined to adjourn this matter for a week so that for a week to give chance to the respondent side to appear in this case. Let this matter be listed. You inquire. Otherwise, you may have to issue notice. Let this matter be listed after a week on a date to be fixed by registry.
Wait, please, Your Honor. This is an appeal by the Union of India, that is the Railways, against the judgment and award passed by the Railway Claims Tribunal dated 27/4/2011. Now, the respondent herein were the original claimants before the tribunal. Their grievance was that Railway had levied certain punitive charges for overloading of a wagon, of certain wagons in the consignment. And their contention was that there was actually no overloading, so they claimed for refund. That application was allowed. Now we have filed the appeal against the judgment. Now our contention in the appeal is that it's an absolutely unreasoned and cryptic judgment, my lord. Nothing is discernible from the judgment as to what conclusion has been arrived at by the tribunal and on what basis. No evidence, nothing has been discussed. So
But
it's a
it is
fit case for
14 years.
14 years. It's a fit case for, my lord, remanding back. But before that, my lord, before I take your lordship through the judgment, I would like to place section 73 of the Railways Act for your lordship's and perusal. In fact, it was heard many a times but could not be disposed of. Somehow got adjourned time and again. This is the only relevant provision.
Section
Section 73. 11th provision in connection with the case. Section 773, my lord. Punitive charge for overloading a wagon. As your lordship got that, my lord.
Yes.
Now, the heading says, section 73, punitive charge for overloading a wagon. Lordship will take note of that word wagon, my lord. Now, I'm reading out the section. Where a person loads goods in a wagon beyond its permissible carrying capacity as exhibited under subsection 2 or subsection 3 or notified under subsection 4 of section 74, Railway Administration may, in addition to the freight and other charges, recover from the consignor, the consignee, or the endorsee, as the case may be, charges by way of penalty at such rates as may be prescribed before the delivery of the wagons. Now, in this particular case, my lord, the railways detected, my lord, overloading of certain wagons in the consignment, my lord. The consignment contains several wagons, my lord. The entire train, it contains around 42 wagons. But the overloading was only in certain wagons, not in the entire consignment. So, being agreed, they filed the original application, and that was allowed. Now, I'd like to take your lordship through the judgment, my lord.
Railway impose some penalty.
Punitive charges against the overloaded wagons, and that is permissible under section 73 of the Railways Act. Now, if your lordship takes up the judgment, starts from page . I copy, my lord, the paginations are not there.
One page judgment.
From the judgment, my lord. Ashwin got that judgment. Judgment passed in claim application number
Yes.
OA3. I'm reading out now. The railway collected
freight on allegation of overloading. As per applicant, they booked 967 metric ton, which is permissible weight. Lordship will mark this letter, my lord. 976 metric ton, which is permissible weight for charging of freight at normal traffic rate. But the railways told after you reweighed the goods, they found it contained 988.4 metric ton, and even then it increased to 998.9 metric ton on the allegation of overloading, including penal freight for imaginary weight, which is totally wrong, and for which the refundable amount comes to rupees 52,968. And the applicant hold railways fully liable to refund the said amount with full cost and interest. Notice on the same application was given to the respondent, who filed a written reply taking certain objections, ways that the application is not maintainable as the same is not verified by proper person having authority. Respondent railway has not admitted that the applicant is entitled for the freight overcharge of rupees 52,968 and prayed for dismissal of the case. Now, these were the next page, my lord. The issues, those were framed in the case, my lord, are reflected in the judgment, my lord. Issue number 1, 2, and 3, lordship. 1 and 2, lordship may kindly skip. Those are not relevant for a adjudication of this appeal, my lord. 3 and 4 assume significance, my lord. Issue number 3, whether the respondent is justified in realizing the penal freight on account of overloading and proves that there was overloading. Whether it was proved that there was overloading, and whether the respondents can charge freight on account of overloading. Number 4, whether the applicants prove that they have not overloaded and they have wrongly levied penal freight. Now, these were the documents exhibited. Issue number 1 and 2, lordship may kindly skip those are not relevant. Lordship may kindly come to second last page of the judgment, my lord, where issue number 3, 4, and 5 have been decided.
Yes.
Lordship has got that, my lord, issue number 3, 4, and 5?
Yes.
Now, for the purpose of convenience, all the issues being decided together, as per railway receipt, railway collected freight on 998.9 metric ton. The applicant has stated in his application that railway collected freight on allegation of overloading. As per applicant, they booked 967 metric ton, which is permissible weight for charging of freight at normal rate. But the railway told that after reweighment, the goods, they found it contained 988.4 metric ton, and even then it increased to 998.9 metric ton on the allegation of overloading, including penal freight for imaginary weight, which is totally wrong. In support of his argument, the applicant has relied on the judgments passed by this honorable tribunal in OA number so and so, and the judgment passed by the Honorable Guwahati High Court in MFA number so and so. The condition of weighbridge and the weighbridge certificate submitted by the respondent does not clear the point for which the applicant has filed the claim. No other document submitted by the respondent in support of their claim. So there is no dispute in the payment of excess freight made by the applicant. As per applicant's calculation, the applicant has loaded 967 metric ton, which is permissible weight for charging of freight at normal traffic. But the railway told after reweighment of goods, they found it contained 988.4 metric ton, and even that it increased to 998.9 metric ton on the allegation of overloading, including penal freight for imaginary weight, which is totally wrong. However, the railway collected freight on 998.9 metric ton at booking point, which is imaginary. Thus, it stands proof that the respondent has realized a freight on incorrect basis. Respondent has not submitted any document in support of their claim. Hence, the issue is decided in favor of the applicant. Nothing, my lord, no reason, nothing, absolutely cryptic order, my lord. No reason has been assigned. On what basis the decision which has been arrived at has been so arrived, my lord. Now, if Lordship turns to the calculation part,
No, on what basis railway claimed that it was 988.4 metric?
on what basis? Lordship may kindly turn to the next page, then I'll answer those queries also. The other perversity, my lord, I'd like to point it out before you, Lordship. The calculation part. Lordship is, got that, my lord, page number 4, internal page number 4 of the judgment. Calculation. Total weight book 988.4 metric ton. And they said in their application that they had booked 967 metric ton, which is the permissible quantity. Now, this itself is an admission that there was an overloading, my lord. Now, thereafter, total freight paid by the applicant as per RR rupees 11,58,406. Correct freight charging rate rupees 1,189.80 per metric ton. 988.4 metric ton booked into so and so, the amount comes to 11,75,998. 6% rebate for Northeast state booking. This is a rebate which is applicable to all consignees, my lord. Persons who book consignment for transportation by the railways within the northeastern areas, my lord, are entitled to a 6% rebate. That 6% rebate amounts to rupees 70,560. So the total amount comes to 11,05,438. Now the total freight paid by the applicant was 11,58,406, and the freight that should be paid according to this calculation is 11,05,438. So the refund comes to 52,988. Now even this calculation, my lord, what they have done, they have calculated the freight on the entire consignment, whereas railway did not collect the punitive charges on the entire consignment. It was only on particular wagons which were overloaded. Even this calculation is, my lord, perverse, my lord. They could not have arrived at this calculation because the punitive charge which was levied against the respondents herein were levied against particular 3 or 4 wagons only. Now they have calculated the normal freight on the entire consignment.
You produced any documents?
Yes, documents are there in the LCA, my lord. The railway receipts, the respondents, they themselves have placed, my lord. And what the railways have placed, my lord, those are also on record. In page 2. There is no reason assigned for arriving at the conclusion that the wagons were not overloaded. Nothing, my lord. I've placed before your lordship the findings of the tribunal at page number 3, while deciding issue number 3, 4, and 5. On what basis it came to a conclusion that railway had collected freight on 998.9 metric ton?
Your railway receipt shows.
Railway receipt shows, my lord.
That you collected.
Nothing has been discussed in the
Right on 998.
998.
0.9 metric ton.
It's the railway receipts, my lord.
Yes,
It's not possible. If it's there, my lord.
that is their claim.
It's their claim, my lord. Because the punitive charge is not levied on the entire consignment. It could not have been. The permissible limit of, my lord, filling a wagon is up to 52 metric tons, my lord. A wagon cannot be filled beyond 52 metric
No,
tons.
is there any document to show that that you have imposed punitive charge against individual wagons?
Yes, railway receipts are there in the
Which
I'll say itself, my lord.
Putul. NCLs. Give
It's
it to
reflected in the LCR.
give it to him.
On which wagons the punitive charges have been levied, my lord.
Flag.
Even in other words, the Act says, my lord.
Flag them.
Given, my lord,
The
Yes.
punitive charge cannot be
You
levied.
flag those. What is your submission?
Firstly, in this matter, in the WS, it has not been denied. And apart from going into that aspect, Lordship may kindly look upon the impugned judgment. The paragraph which my learned friend had just read, my lord, I'll just apply some emphasis on certain portion, my lord.
But the impugned judgment itself says that at one place it says that you booked 967 metric ton.
Yes, sir.
But while calculating it, calculates at the rate, assuming that you booked 988 metric tons.
Yes.
So that is a discrepancy.
That is a discrepancy, my lord. In fact, it is against me only, my lord.
Yes.
Upon the railway, after the Railway Claims Tribunal have gone through the reports and the documents and everything, they have found that, okay, it is supposed to be 988 metric ton instead of 967 metric ton. That is where, my lord, I am not challenging, I'm not into that aspect, my lord. My lord, my humble submission is, it is the duty as per section 73, my lord, it is the duty upon the railway authority to prove that there has been overloading of the wagons, my lord. Secondly, my lord, the calculation of the claim has been made under 988.4, not under 967 metric ton, my lord. And apart from that, my lord, there is our Honorable High Court judgment in this respect, my lord, under section 73, my lord, which is stating that the railway cannot impose penalty for overloading of the consignment at the originating station. In our case, my lord, the railway has imposed penalty for overloading in the originating station. So our High Court judgment is stating that, my lord. I'll just place that.
Which is the document which shows that this overloading penalty was.
In the railway receipt itself, in the originating station.
Where
itself,
is
they were
the-
collected, my lord.
Where is the railway receipt?
My learned friend is just,
300.
yes, ma'am.
There are several railway receipts, my lord. Only those railway receipts which have flag mark, my lord, in those, my lord, the penalty was levied. At the bottom, my lord, lordship will find one word 300 multiplied and the overloaded portion is also reflected herein, my lord, 4.5, something like that, my lord. These are the railway receipts on which, my lord, there was overloading detected. In fact, these were the wagons.
So, no, just a minute, keep it with yourself for a moment. For a moment. For how much total weight
Well-
the freight was collected by railways?
It's if the overloading is more than 2 tons above the permissible limit, then the penalty punitive charge is levied, my lord. Up to 2 metric ton, that is condoned always. If the overloading is more than 2 tons, 2 metric tons, then only at that time, my lord, that was the rule. Now they cannot even overload for 100 kg, my lord. Now that is not at all permissible. During that particular period of time, my lord, 2 metric ton was permitted.
No. For how much total weight of the consignment the respondent paid you the freight?
In one wagon, there was
Not
4.5.
total, because here the calculation is of total.
Now they have calculated, the Honorable Tribunal has calculated the amount on the entire consignment. That could not have been. That itself is the perversity, my lord. Because the punitive charges which the railway have levied, my lord, was on particular wagons, not
No,
on
it may be, but suppose somebody has booked a consignment.
consignment.
It takes more than one wagon to carry that consignment. Whether he will pay individual wagon wise freight or
If somebody has booked a single wagon, he will pay for that wagon only. But if somebody books the entire train, my lord, in this case, That has happened, my lord.
Entire.
They have booked the entire rack, my lord. Only one consignor.
So whether he has to pay wagon-wise
Totally.
railway receipts will be issued.
Yes. The rail receipts are issued wagon wise, my lord. It's there in.
All railway receipts are there.
Payment are been made in total, my lord. And my lord, in the original application, I have mentioned 998.9 metric ton. The freight has been levied in 998.9 metric ton, the penalty. And however, we have loaded less than 967 metric ton. And my lord, it was not denied by the railway. Only in respect to overloading, 967 was denied, but 998.9 metric ton has not been denied, that the railway has imposed penalty and levied freight on the basis of 998.
No, absolutely not, my lord. We have denied, my lord. We have categorically stated that the penalty was levied on the particular wagons which were overloaded. It's in our written statement and the written argument that we have filed before the.
How much they booked?
The booking is not done in that manner, my lord. They book the entire consignment and they have the liberty to book to a particular limit and a particular weight.
What is the limit?
That is, there are markings in the wagons. Up to that limit, they can book and they
No,
cannot.
at the time of issuing railway receipts, at the time of booking.
All wagons, my lord, there are markings. Up to that mark, they can load and there's a particular load carrying capacity. In some cases, it's 54 metric tons. In some cases, it's 62 metric tons, my lord. It depends on the individual wagons, my lord. So the total comes by combining all the carrying
No,
capacity of all the
respondent,
wagons, my lord.
Mr. Rathi, on what basis you are claiming that you booked 967 metric ton?
My lord, based on our loading and our my lord, based on our loading and our records, we alleged that we have loaded 967, my lord. Since the railway are imposing, my lord, penalty for overloading, it is the duty
Or
of the
burden is
railway,
on them. That is your submission.
my lord.
That it was was on them to prove the overloading.
Yes, my lord, they have not produced any documents, payment chart, payment sheet, nothing. It has been mentioned in the impugned judgment itself that no document has been produced which proves that there has been overloading of the consignment, my lord. And apart from that, my lord, in the originating station, the railways cannot even impose any kind of a punitive charge. Our Honorable High Court has held in 2 occasions, my lord. One is a very recent judgment passed by Honorable Justice Devasys Barua, my lord, in this matter. In a similar situation. Exactly similar situation, man.
Yes, what is your submission?
These are the rail.
My lord, if your lordship may look upon this judgment, my lord, which is stating railway cannot even.
Mr. Sharma, you are done with your submissions. You have,
No, the railway receipts, which my lordship has asked me to flag mark,
yes.
wherein the overloading was mentioned. So he cannot say that there was no document. These documents are itself there, my lord.
Okay, what is your submission?
My lord, firstly, the payment chart has to be produced to prove that since there has been a repayment bid done. At the time of payment, overloading was not detected. But at the time of repayment was done, my lord, in the RCT judgment para 1, it has been stated repayment was done and the allegation of overloading was levied upon me, my lord. Thus, my lord, the payment certificate is the most crucial document which has to be furnished, my lord.
So payment certificate was not furnished in this case.
My lord. Secondly, my lord, onus of proof is upon the railway, which they have failed to do so, my lord. My lord, payment certificate, if your lordship may look upon page number 3 of the impugned judgment, issue number 3, 4, and 5, in respect to issue number 3, 4, and 5. Honorable learned RCT has given a detailed elaboration in regard to payment certificate.
Yes.
I'll just read, my lord. As per the RR Railway collected freight on 998.9 metric ton, the applicant has stated in his application that the railway collected freight on allegation of overloading. As per applicant, they booked 967 metric ton, which is permissible weight for charging freight at normal traffic rate. But the railway told that after reweighed, the goods they found contain 988.4 metric ton. And even then, it increased to 998.9 metric ton on the allegation of overloading, including penal freight for imaginary weight, which is totally wrong. In support of this argument, the applicant has relied on the judgment of the Honorable Tribunal in so and so and the judgment of the Honorable Guwahati High Court in MFA 31/2010. The condition of weighbridge, emphasis applied from here onwards, my lord. The condition of weighbridge and weighbridge certificate submitted by the respondent does not clear the point for which the applicant has filed the claim. No other document submitted by the respondent in support of the claim. So there is no dispute in the payment of excess freight made by the applicant, my lord. There might have been some payment certificate been produced, but it is not in regard to my present claim, my lord, as held by the learned RCT. And also there is another, my lord, one more aspect which can be derived from this observation, my lord. In the first time when the reweighment was done, they detected 988.4 metric ton. And the second time when they reweighed my consignment, they detected 998.9 metric ton. The weighments, the weighbridge is itself showing, my lord, different result whenever it has been reweighed. As per the observation, my lord. And I'll not even go into this aspect, my lord. As per our Honorable High Court judgment, my lord, I am very much secured that the railway cannot impose any kind of a penalty upon me at the originating station, my lord.
What do you mean by that?
Lordship will kindly look upon the judgment which I have given, my lord.
Yes.
My lord, is it MFA 31/2012? I have given two judgments, my lord.
Yes.
My lord, if your lordship may kindly look upon para 9. Para 9, it is stated, from the materials on record, this court could not find any document which would suggest that there was an overloading by the applicant.
You have flag mark those documents,
Those railway receipts.
which indicates that there was overloading. Whether those railway receipts indicate that there was overloading in particular wagon.
Indicated in some cases it's 4.5 metric tons, in some cases it's it has to be above 2 metric ton. Then only the punitive charge is levied, otherwise not. Otherwise not. Because during that period, concession of 2 metric ton was given, my lord.
Mr. Sharma, you mark, otherwise it will be difficult to.
Documents, my lord, why?
You take your time because your submission is also as technical. Okay, I'm reserving the judgment.
My lord, in regard to section 73, if the lordship may allow me.
That in this case, the penalty was levied at the originating station.
Yes, ma'am.
That how can you show?
My lord, in para 9, in para 9 itself, it has been.
Para 9, yes. No. That is the law. Pencil change kar diyo.
You take pen, but
Now take a different pencil. Yeah.
In our case,
In
my lord,
your
the
case, you
my
have
lord,
to.
irrespective of the fact that whether the overloading has been detected in the originating station, I'll just prove that I'll satisfy your lordship with that query as well. But my lord, irrespective of the fact, the overloading has been detected at the originating station or in transit. Railway cannot transport the overloaded consignment. They have to offload the overloaded consignment and have to and can take cost for offloading and everything. I have to bear that, but penalty for overloading of the consignment cannot be invoked. My lord, it has been stated in 73, my lord, para 9, my lord. Railway cannot transport overloaded consignment. They are transported.
Yes, please read.
From the materials on record, this court could not find any document which would suggest that there was an overloading by the appellant, which the appellant herein ought to have proved before the learned tribunal. Be that as it may, this court had put a specific query upon the learned counsel for the railways as to how the appellant had permitted the overweight when it is mandate of the provision of section 73 of the Railways Act that in case of a detection of a overloading in the forwarding station, the railway authority should have unloaded the said excess load and recovered the cost of such loading and any charge for detention of any wagon in that regard. The learned counsel, however, submitted that taking into the account that the weight did not exceed much the railway authorities have permitted to carrying out the load and the applicant did not raise any protest then. Subsequently, my lord, in para 10, this court has duly taken note of provision of section 73. And from the said, it is seen that the railway administration could not have permitted carrying out of any load beyond the capacity of the wagon, that too when it is detected at the forwarding station, my lord. And my lord, this lastly,
In your case, where it was detected,
in the originating station, my lord.
then they could not have carried that.
Exactly, my lord.
That is your submission.
It's not- so
That is his submission.
that is not a fact. Just to clarify that point, that submission which has been made based on the judgment, my lord, paragraph 9. Also, may kindly peruse section 73 of the Railways Act. Once again, my lord. This judgment has been delivered based on section 73. There is no such mandate, my lord, that it has to be unloaded. The railway may, my lord. Lordship may kindly come to page, section 73. Also, got that, my lord? The
Yes.
proviso. Provided that it shall be lawful for the railway administration to unload the goods loaded beyond the capacity of the wagon if detected at the forwarding station or at any place before the destination station or at any place before the destination station and to recover the cost of such unloading and any charge for the detention of any wagon on this account. It's not mandatory, my lord.
But that has to be the course which railway should adopt.
Can adopt, but may not also, my lord. It's not that they have to, we have to, my lord, unload it at the forwarding station itself, my lord.
Heard Mr. B. Sharma, learned standing council railways.
Right.
Also heard Mr. D. Rathi, learned counsel for the respondent. Reserving the judgment.
My lord. My lord, I have just given one more judgment. I'll not read that, my lord. That is an identical case, very identical case, my lord. In fact, parties are also same. Union of India Appeal and respondent is also same, unique quotator, my lord. Wherein it has been stated that the same proposition, my lord. Same issue that railway cannot transport the overloaded consignment. They can just, they cannot impose any punitive charges upon me, my lord.
Okay.
Para 10 is the relevant. My lord.
You flag those.
The railway receipts. Only those particular flag mark ones. The other ones where there has been no overload detected, they have not marked it. Only the particular ones where the overload has been detected.
Judgment reserved.
Much okay.
Hearing concluded.
My lord, your lordship, kindly see the last order. The order is 31/7/2025.
Now what is to be done?
My lord, last two occasion, this is third, this is fourth occasion, they are not appealing. That's why in the last occasion stated that, my lord, if not, then they will, my lord, pass the appropriate order.
What is the appropriate order?
So appropriate order is dismissed for default, my lord,
Yes, there is no other option.
option, my lord. Because that's why again and again they have given chance. The lord, significantly earlier two occasion, they have not appeared. 9/9/2019, 22/9/2019. That's why last occasion, my lord, ultimately the solution waited, my lord, and then ultimately has your lordship got it, my lord, order last.
Yes, none has appeared for the appellants on call. Mr. T.J. Mohanto, learned senior counsel, assisted by Ms. P. Bhattacharya, appears for respondents. On perusal of the records of this, on perusal of order dated 31/7/2025, as well as 22/10/2019, it appears that on two consecutive dates, when this appeal was listed, called on for hearing, the appellant was absent without steps. In view of above, this regular second appeal is dismissed for default.
Next one, same, both.
Both the cases, separate orders, same order, dismissed for default.
Develop.
And for the respondent lordship,
My lord, Mr. S.P. Chaudhary is on X, my lord. Maybe first of all,
We'll adjourn it. Heard, Mr. This is item number. You are not there.
I'm not in this.
Heard Mr. S.D. Purkasta. And
SK
sorry. Heard Mr. S.K. Ghosh. Learned counsels submitting on behalf of Mr. S.P. Chaudhary, learned counsel for the appellant, who submits that the learned counsel for the appellant is on legs in a different court. Also, Miss B. Hajorika, appearing on behalf of Miss R. Chaudhary, learned counsel for respondent number 1 to 9. Let this matter be listed
Thursday lordship, some urgency.
in the next week on a date to be fixed by registry.
Tuesday lordship, next Tuesday.
Next week. Registry shall fix the date.
May I please, Your Worship? My lord, before I should take your lordship to the impugned judgment, I would like to narrate to your lordship certain relevant facts of the case. It is a dispute between landlord and tenant, and we are under section 115 before your lordship. My lord, prior to the filing of title suit number 185 of 2013, wherein
Against the appellate court's order.
the appellate's court.
Okay.
Appellate's court. I will take your lordship to the appellate court order, but before that, my lord,
I would just narrate the brief facts of the case, which has happened in between the landlord and the tenant. My lord.
Yes.
My lord, prior to the
Yes.
My lord, prior to the filing of the title suit number 185 of 2013 by the landlord on only one ground of bona fide requirement, my lord, I as a tenant had filed a suit upon my landlord bearing title suit number 462 of 2012. So 2012 was prior to the filing of the suit by my landlord, that is 185 of 2013. Now, my lord, the suit which I filed was under for protection that I should not be evicted forcefully by the landlord. That was granted, my lord. Injunction was also given, and the learned trial court came to the finding that yes, I should not, I do have a protection under the law that without taking due process of law, I should not be evicted. That was there. My lord, while filing the written statement in that title suit, number 462 of 2012, the landlord never took the plea that he requires the premises. No any counterclaim was filed. He never took the plea that there is any requirement which is said to be the bona fide for the landlord to evict me from the premises. And that suit, my lord, was decided.
But in that suit, issue was different.
Issue was
Issue
different.
was not to evict you without taking due process.
Yes, but my lord, if the eviction of mine is required in any case, if the eviction of mine is required on the bona fide ground requirement or on the bona fide ground, then at least the landlord should have taken that ground into that he needs the premises. No mention was there, my lord.
Okay.
Now thereafter, my lord, notices were exchanged.
In the subsequent suit.
Subsequent suit, prior to the filing of the subsequent suit in the year 2013, notices were sent.
2012 suit,
2013 suit.
13 suit.
Yeah, 2012, my lord, is already decided in my favor.
After disposal.
Yes, my lord.
Okay.
After that, the landlord issued notice to me for eviction. In that also, my lord, no ground was taken of bona fide requirement. I will take your lordship to those letters also, which are annexed. Now thereafter, my lord, this title suit number 185, 2013 was filed, wherein for the first time, the landlord has taken the ground of bona fide requirement. My lord, prior to that, there were 3 agreements whereby, my lord, rupees 1,25,000 were taken as advance, 1,25,000 was taken as advance with the condition that advance will be adjusted against the rent. 1,25,000 advance will be adjusted against the rent. Prior to the adjustment of that advance, my lord, the suit was filed for eviction of mine on the sole ground of bona fide requirement. Now, keeping that aim in view, my lord, I would like to take your lordship to the judgment of the First Appellate Court. It is reflected as page number 87 to 101. I do also understand, my lord, that the Honorable Supreme Court in time and again has come that it is the prerogative of the landlord to evict the tenant on the ground of bona fide requirement. But that bona fide requirement, my lord, according to me, must be honest, must be genuine, and must be well thought, not afterthought.
Yes.
My lord, page number 87, my lord. I will take your lordship to this appeal coming on for final hearing on 35/2019 in presence of so and so and so and so. That is there, my lord. After that, the judgment is starts from page number 89. Page 3, internal page 3, regular page 89, my lord. May I read your lordship?
Yes.
Yes. The appeal under section 96 read with order 41 of the CPC has been preferred by the appellant public defendant against the judgment and decree dated 25/11/2016, passed by the learned Municip number 2 Kamrup Metro at Guwahati, entitled suit number 185/2013. On receipt of the appeal memo, notice was issued to the defendant respondent, and case record of title suit number 185/2013 was called for. Respondent appeared through his learned engaged counsel and has contested the appeal. I have heard the learned advocate for both the parties, gone through the memorandum of appeal and the case record of title suit number 185/2013. The case of the plaintiff in brief is that the plaintiff and his brother Muhammad Salauddin Ahmad are the absolute owner of a RCC building, which is situated over his plot of land covered by DAG number 433 of KP Patta number 2868 of Village Sahar Guwahati Part 3 under Guwahati Mauja District Kamrup Metro. That as per the partition between the plaintiff and his brother Muhammad Salauddin Ahmad, the plaintiff got the entire second floor, including the shoot premises of the aforesaid building. In the month of July 2002, the plaintiff proposed to let out the RCC hall in the ground floor of the said building, measuring 18 feet height, 40 feet length, and 25 feet breadth, along with attached sanitary latrine and bathroom. The defendant desired to take said room on rent at the rate of rupees 3,500 per month, payable by the defendant to the plaintiff within first week of every month. The tenancy period was started on 12/8/2002 to the end of the month of August 2007 for a period of 5 years, and a written agreement was executed between the parties on 12/8/2002. And defendant had taken possession over the said room on the same day. It was agreed between the parties that the defendant has paid rupees 1,25,000 as advance rent to the plaintiff, and the said advance rent was getting adjusted with monthly rent at the rate of rupees 1,000 per month. Thereafter, the payable rent till the month of August 2007 was rupees 2,500. That the tenancy period was come to an end on the month of August 2007, but the defendant, instead of vacating the shoot premises, requested the plaintiff to renew the tenancy for another 5 years. However, on being satisfied with the request of the defendant, the plaintiff has extended the tenancy period for another 5 years with effect from 1/7/2009 with 2007 till the end of the month of August 2012. In this respect, the written agreement was executed on 1/10/2007, and the rent was mutually fixed at the rate of rupees 5,000 per month. That the advance rent of rupees 1,25,000 only was adjusted at the rate of rupees 1,000 per month, with the house rent of rupees 2,500 per month for the period from 12/8/2002 to the month of August 2007. And for the period of a sum of rupees 60,000 only was adjusted against the house rent, and thereafter another rupees 60,000 was adjusted against the house rent for the next 5 years. And after adjustment of rupees 1,20,000 against the house rent, still the remaining amount of rupees 5,000 is in the hands of the plaintiff. That the plaintiff has stated that the tenancy period was over on 31/8/2012. On 1/8/2012, the plaintiff met the defendant and informed him to vacate the shoot premises on or before 31/8/2012. The plaintiff was not willing to renew the tenancy again. On 31/8/2012, the defendant did not vacate the shoot premises. Having no other alternative, the plaintiff issued a notice to the defendant on 1/9/2012, giving him 15 days time for vacating the shoot premises, but the defendant had not vacated the shoot premises on or before 15/9/2012. That the plaintiff again sent pleader's notice on 30/9/2012, asking him to vacate the shoot premises within 7 days from the date of receipt of the notice, but the defendant, instead of vacating the shoot premises, has filed a suit being title suit number 462/2012 against the plaintiff, seeking a decree of declaration that he is a bona fide tenant the plaintiff alleged that the alleged facts mentioned in the plaint of TS number 462/12 are false and concocted. That the plaintiff further stated that after August 2012, the defendant is not a tenant under him. The plaintiff is educated, unemployed youth, having his wife and a minor child, and as such, that expenditure to maintain his family is increasing day by day, and he has no other sources of income to maintain his family members. So he decided to decided to earn business in the said premises. Run hobo minor, it will be run is R is missing. The plaintiff has not other accommodation for running a business to earn livelihood to his family members for the shoot premises is required for bona fide of the plaintiff, which is unauthorized and occupied by the defendant public tenancy. Having no other option, the plaintiff has filed this suit for ejectment of the defendant from the shoot premises on bona fide requirement of the same. The defendant contesting the suit and filed a written statement against the plaint of the plaintiff. The defendant has categorically denied all the averments made in the plaint by the plaintiff, stating that there is no cause of action for filing the suit is bad for non-joinder of necessary party such as Muhammad Salahuddin Ahmed. That defendant has stated that the plaintiff has violated the law relating to tenancy by demanding exorbitant rent from the defendant, and when he refused to bow down to the said illegal demand, then the plaintiff refused to accept the rent tendered to him by the defendant from the month of September 2012. Due to refusal of the plaintiff, the defendant has started to depositing the same with process fee in the court. The defendant has denied the ground on bona fide requirement of the shoot premises by the plaintiff. The plaintiff has stated that he is completely unaware of any kind of agreement regarding the shoot premises executed between the plaintiff and his brother, Muhammad Salahuddin Ahmed. That the defendant has stated that the rent for the shoot premises was collected by the plaintiff as and when he required. That the agreement was executed on 12/8/2002, but the possession over the shoot premises was taken by the defendant on 1/9/2002. The defendant has agreed and the rent was increased from 3,500 to 5,000 by overlooking the contents of the agreement dated 1/8/2002. That since the month of September 2012, the plaintiff refused to accept the rent tendered to him as per agreement 1/10/2007, and thereafter the rent has been deposited before court, that is rupees 6,000 per month. On 30/9/2012, defendant had received a pleader's notice asking him to vacate the shoot premises or to pay compensation amounting to rupees 2,000 per day. That defendant has stated that the said notice was sent only to pressurize the defendant. On 12/10/2012, the plaintiff disconnected the water supply and blocked sewerage pipe of the shoot premises. Thereafter, the defendant has filed a title suit number 462/12 seeking declaration against the plaintiff that he is a lawful tenant. That the defendant has filed his written statement and categorically denied all the averments and claim on the plaint of the plaintiff and prayed for dismissal of the suit. On pleading of the parties, both the sides went on trial with the following issues. There are 5 issues, my lord. Whether there is any cause of action for the suit, whether the suit is lead for non-joinder of necessary party, whether the plaintiff has any bona fide requirement of the shoot premises, whether the plaintiff is entitled to the decree, to what other relief, if any, the parties are entitled to. During trial, plaintiff examined himself as a witness. Defendant, on the other hand, also adduced 2 witnesses. The learned trial court, after hearing learned counsel of both sides and after appreciating evidence available on record, was pleased to dismiss the suit. Being highly aggrieved by the above judgment and decree of trial court dismissing the suit of the plaintiff, the plaintiff has preferred this instant appeal on the following amongst other grounds.
The
For-
decree was reversed.
Yes, yes.
No, my lord.
No, my lord.
Concurrent findings.
Concurrent finding, but here it is wrongly mentioned in that. Dismissing the suit of the plaintiff, suit was.
It should have been decreed this way.
Yes, my lord. This part is wrongly mentioned. The appellant plaintiff has preferred this appeal on the following amongst other grounds. For that, the impugned judgment is not in tune with the evidence on record, both oral and documentary, and as such, the same is perverse and is liable to be set aside and quashed. For that, on perusal of the impugned judgment dated 25/11/2016, it appears that the learned trial court has decided the issue relating to cause of action in the positive merely on the ground that there was rival contentions between the parties. Rather, the learned trial court ought to have examined the genuineness of the plea of bona fide requirement made by the plaintiff in deciding such issue in the negative, and being not done, the decision arrived at by the learned trial court in respect of issue number 1 is erroneous and is liable to be set aside and quashed. For that, there was no issue involved in the suit relating to default in payment of rent, and such being the factual position, the learned trial court ought not to have discussed about such issue while deciding the issue number 1. But as the same has been done by the learned trial court, the decision arrived at by the learned trial court in respect of issue number 1 cannot be said to correct and is liable to be set aside and quashed. For that, though the renewal of the tenancy as per Exhibit 3/Exhibit B agreement was at the option of the plaintiff, but the plaintiff, while issuing the reply letter dated 1/9/2012 and the legal notice dated 30/9/2012, did not assign any reason for declining the request of the defendant for renewal of the tenancy, and hence the plea of bona fide requirement of plaintiff cannot be said to be honest and genuine, and the same being merely a wish and desire of the plaintiff, the issue number 3 and 4 ought to have been decided against the plaintiff, and that being not done, the impugned judgment dated 25/11/2016 is bad and is liable to be set aside and quashed. For that, the facts and circumstances of the case as well as the evidence on record does not warrant the passing of any decree for ejectment of the defendant from the suit premises, and also for passing of any direction to the plaintiff to return the advance rent of rupees 5,000 to the defendant, and on the contrary has been done by the learned trial court. The impugned judgment dated 25/11/2016 is bad in facts as well as in law and is liable to be set aside and quashed. From the grounds of the appeal and the pleading of parties, points for determination emerges in this appeal is: points for determination number 1, my lord, whether plaintiff has had bona fide requirement of the tenanted premises. I have heard the learned counsel of both the parties also peruse the impugned judgment and other materials available on record to arrive at a decision on points, decision and reasons thereof. Point number 1, whether plaintiff has bona fide requirement of the tenanted premises. The evidence on record, particularly the prime documents of the parties, that is the tenancy agreement dated 1/10/2007, which is marked as Exhibit 3 by the plaintiff and marked as Exhibit B by the defendant, reveals that there is a specific stipulation in the clause number 3 and clause number 5C of the aforesaid tenancy agreement to the effect that renewal of tenancy shall be at the option of the plaintiff of the landlord. Now, if that be a position, then as per aforesaid mutually agreed terms and conditions, the defendant cannot claim any right to continue with the tenancy if plaintiff wishes not to renew the tenancy agreement in respect of the suit premises, irrespective of whether defendant is willing to pay enhanced rent or not. The reason being that the claim of the defendant to continue with the tenancy will be hit by estoppel, by deed, which rests on the principle that when a person has entered into a solemn engagement by deed under seal with another party, he or the person claiming through or under him shall not be allowed to set up a contrary of his assertion in the deed. In other words, no man shall be allowed to dispute his own solemn deed. So in view of aforesaid mandate of law, the defendant oblique tenant is bound by his own agreement of tenancy to vacate the tenanted premises when plaintiff is not willing to continue with landlord-tenant relationship with him, as the agreement will bind the parties and the defendant is bound to comply with the terms of the agreement, which was created with mutual consent, keeping in view the interest of both sides. Hence, in view of aforesaid provision of law, I am of a considered opinion that the defendant is liable to vacate the suit premises when the plaintiff is not willing to continue with the tenancy after expiry of the tenancy agreement dated 1/10/2007, marked as Exhibit 3. Nevertheless, for the just decision of the case, let us also consider whether the plea taken by the plaintiff that he required the plaintiff premises for bona fide purpose is sustainable. The word bona fide, though not nowhere defined in the Rent Control Act, however, is the general context, its meaning anything, it means anything which is genuine and real, Now let us see whether the need of the plaintiff landlord is bona fide or not. The plaintiff in his plaint averred that he is an educated, unemployed youth, having wife and a minor children, and he earns his livelihood by letting out a part of his ancestral property, which he got out of partition with co-sharers. He further averred that as the expenditure to maintain his family is increasing day by day, and rental income from the suit premises is not sufficient to meet his needs, so he has decided to run a business for his self-employment in the suit premises instead of living upon the rental amount, and for which he warned the defendant to vacate the suit premises. Now, from the aforesaid averment of the plaintiff, what transpired is that plaintiff warned the suit premises for his self-engagement and employment, particularly for running a business in suit premises so as to increase his income in order to maintain his family properly. And we know that it is a settled law that when a landlord claims the property for establishment of his business or for extension of his business to increase his income, same come within the meaning of bona fide requirement. Arathi Saha versus so-and-so, 1995, 3 GLT 97. However, in the instant case, if we draw our attention to the contention of other side, appellant, we will find that defendant oblique tenant, though did not dispute it, that the plaintiff is an educated, unemployed youth, and he has a family consisting of wife and children. But they took a plea that plaintiff have sufficient rental income to support himself and his family, and he also purchased a property within the RCC building in which shoot premises is situated, where he can start a business without disturbing defendant, which the plaintiff, on the other hand, had denied. So let us find out what is the truth in order to decide issue in hand. From the aforesaid disputed facts wherein defendant had asserted the affirmative of the issue and insisted to believe in existence of a particular fact regarding possession of separate property and sufficient rental income. So in the light of provision of law laid down under section 101/103 of Evidence Act, the burden of proof lies upon the defendant, tenant, to establish its claim. Wrong contention, my lord. So let us see whether there is any evidence available on record which can establish the claim made by the defendant, tenant. As regards the first claim of the defendant with regard to the sufficient rental income, if we draw our attention to the evidence on record, particularly the tenancy agreement marked as Exhibit 3 and Exhibit B, we will find that tenanted income of the plaintiff from the rental premises is only rupees 5,000 per month, out of which rupees 1,000 is adjusted against the remaining advance payment of rupees 65,000 out of rupees 1,25,000 given by the defendant to the plaintiff during the first tenancy agreement. Now, if rupees 5,000 is taken as an actual monthly rental income, from the shoot premises, then a serious question arises as to whether can we hold rupees 5,000 as sufficient income to maintain a family of 3 persons in today's inflated economy? The answer, in my considered opinion, would be simply no, because the word maintenance, as we understand, does not mean only fooding, rather it includes everything to enable a human being to lead a life in dignified way. In the other hand, the word maintenance beside fooding also includes within its ambit expenses for medical treatment, expenses for education of children, expenses for clothing, expenses for house tax, etc. So if that be a definition of maintenance, then I am of the view that a meager amount of rupees 5,000, in my considered opinion, can by no stretch of strength of imagination be held as sufficient to support a single person, not to speak of a family consisting of 3 members, out of which 1 is children. So in the light of foregoing discussion, I am of the considered opinion that the claim of the defendant that plaintiff has sufficient rental income is disproved. Now let us come to the second claim of the defendant, wherein he alleged that plaintiff had property with RCC building besides the shoot premises, where he can start a business without vacating the defendant. Now, if we pursue the evidence available on record, we will find that there is no iota of evidence relating to the aforesaid claim of the defendant. The evidence of defendant is silent as to where in RCC building, other than the shoot premises, that other property of plaintiff as claimed by defendant is situated, and which can be allegedly utilized by the plaintiff for doing his business. Rather, the evidence on record disclose that the entire property wherein the RCC building is standing is an ancestral property of plaintiff, wherein besides plaintiff, his brother also has share in the property, and his brother and mother are also residing in the other part of the building. So under above facts and circumstances, I am of the considered opinion that the second claim of the defendant is also not sustainable, and hence I am constrained to held it as disproved. Now from the above discussion, I am of the considered opinion that both the claim of the defendant is disproved, so the bona fide requirement of the shoot premises by the plaintiff, in my considered opinion, is found to be established. More so when clause 5C of Exhibit 3 further fortifies the aforesaid claim of plaintiff, because if we peruse the contents of Exhibit 2 and Exhibit 3, both the lease agreement meticulously, we will find that except clause number 5C of clause 3, Exhibit 3, and clause number 5C of Exhibit 2, conjointly almost all the clauses are same. And if read clause number 5C of Exhibit 3 and clause 5C of Exhibit 2, we will find that plaintiff from the very inception of the second tenancy agreement made it crystal clear that he is not willing to continue with tenancy in respect of the shoot premises with the defendant after the expiry of the second tenancy agreement, and for which he had brought changes in aforesaid 2 clauses. And it also appears that perhaps for adjustment for balance of rupees 65,000 out of rupees 1,25,000 taken during first tenancy agreement, he was constrained to enter into second tenancy agreement. So in the above backdrop, I am foreclosed from all sides to hold that plaintiff had bona fide requirement of the shoot premises. However, the learned counsel for the defendant side, besides making above claim, also vehemently argued on 2 grounds. Learned counsel submitted that if defendant is asked to vacate the tenanted premises, then defendant will lose his bread and butter, and the plaintiff is a money-minded person, and it is his hunger or money and not bona fide requirement for which he wants defendant to vacate the shoot land. Now let us also answer to aforesaid 2 claims of defendant appellant for the sake of just decision of the case. I have heard the submission of learned counsel, and as regard his first argument, it is to be mentioned that the shoot premises is admittedly used by defendant as godown for keeping the stock in respect of their two numbers of shops running at SS Road and SRCB Road respectively. And if that be a position, then I am of the considered opinion that the question of losing bread and butter by vacating the shoot premises, which is utilized as a godown, cannot arise, as because earning is done in separate business establishment, that is in aforesaid two numbers of establishment, and not in godown, which is a place for keeping stocks only. And I believe the shifting of godown will not affect the business of the defendant, nor they will lose any bread and butter. So, in the light of foregoing discussion, I am of the considered opinion that the first argument of the learned counsel is not tenable. Now, let us take the second argument of the learned counsel. This argument is similar to the fact averred in the WS, which has been already answered earlier, that is the bona fide requirement of the shoot premises by the plaintiff. Nevertheless, for the just decision of the case, I would also like to take up this argument for discussion. The learned counsel of the defendant, in order to establish their aforesaid claim, the plaintiff is money-minded, had invited the attention of this court to para number 8 of the written statement and contention of letter dated 30/9/2012, marked as Exhibit E. The learned counsel argued that plaintiff at the time of renewal of second tenancy agreement, instead of enhancing 15% over monthly rent of rupees 3,500, that is rupees 525, as per their earlier terms and conditions, had enhanced 1,500. Further argued that plaintiff in his quit notice as demanded rupees 2,000 per day from the date of expiry of the second agreement till the date of vacating the tenanted premises for occupying the shoot premises beyond tenancy agreement. And these conducts and demands of plaintiff indicates towards the fact shows that he is money-minded person. Learned counsel further reiterated that if defendant pay rupees 2,000 per day, then plaintiff will have no objection and defendant can occupy the tenanted premises. I have heard the submission of the learned counsel of the defendant, and I am of the considered opinion that as regards the first claim of the defendant regarding the enhancement of the rent to rupees 1,500 in second agreement instead of rupees 525, I am to state that these allegations is not sustainable at this stage, as because they themselves had ratified the enhancement by accepting the second agreement. So aforesaid the allegation of the defendant is set at rest. Now, as regards allegations regarding demanding of rupees 2,000 per day is concerned, I am to state that the conclusion drawn by the defendant from the contention of aforesaid letter is not convincing, as because if we read the entire content of the letter along with aforesaid para 6, we will find that no interest of plaintiff could be gathered for continuation of tenancy with the defendant by imposing rupees 2,000 per day, because the word is till date of vacating of the tenanted premises itself negates the claim of the defendant and indicate towards the fact that an amount of rupees 2,000 was demanded by the plaintiff in order to compel defendant to vacate the tenanted premises as early as possible. So in the light of foregoing discussion, I am of the considered opinion that these arguments of the learned counsel holds no water. Hence, under above facts and circumstances, I am of the considered opinion that the shoot premises as required by the plaintiff for bona fide use. Hence, under above facts and circumstances, I am of the considered opinion that the shoot premises as required by the plaintiff for bona fide use. Accordingly, the issue is decided in affirmative and in favor of the plaintiff. Accordingly, the judgment and decree passed by the Learned Municip number 2 on 25/11/2016 in TS number 185/2013 is hereby upheld, and consequently appeal is dismissed with cost. Let a decree be prepared accordingly within 14 days. Send back the case record of title shoot number so and so to the Learned Court of Municip number 2, Kamrup Metro, Guwahati, with a copy of this judgment and decree. Given under my hand, and seal of this court on this 28th June 2019, so and so. Now, my lord, I was not a person who rather pressurized the landlord to enter into an agreement with me in the year 2003. And I was also not a person to fix the rate of tenancy, my lord, at the rate of rupees 3,500. The landlord, being the authority of the premises, formulated a tenancy agreement wherein he fixed the rate of rupees 3,500 for the rent to be raised by him or to be received by him as against the monthly rent. Now, my lord, 1,25,000 was paid or rather demanded by him and paid by me by looking to the quantum of rent which was there fixed by him, 3,500. My lord, the stipulation was that whatsoever the rate of rent be, from the rent of every month, rupees 1,000 will be deducted.
Yes.
My lord, he knew at that time also that he is a married one. He knew that he is a unemployed graduate. He knew that he has no employment. He knew that. And as he was the co-sharer of that property, my lord, co-sharer of that property, along with his brother, he entered into agreement with me. The moment, my lord, both the brothers got the building separated, then this demand came. I adhered to that demand also, wherein I agreed to pay rupees 6,000 per month. My lord, in the first agreement, there was a stipulation that whenever this agreement will be renewed, it will be at the rate of 15%. 15%. 15% over 3,500 comes to rupees 525, my lord. 525 only. But yet, my lord, when he demanded rupees 1,500 excess than that stipulated rent, then I adhere to that also. I abide by. And at that time, he got separated from his brother, never says that I am an unemployed youth, I am a married person, I am having a son, this 3,500 or 6,000 rupees is not sufficient enough for me to pull on my life. To pull on my life. Now, under that scenario, my lord, how a tenant can anticipate that he is not in a position to pull on his life? Because when 525 rupees ought to have been raised, was raised to the tune of rupees 1,500, it itself deems that perhaps 1,000 rupees more will be sufficient enough to pull out his life. And that I adhere to.
But he gave you a notice.
But in that notice, my lord, yes, my lord, I do agree that he gave me a notice. Notice when he gave, my lord, at the time when he got separated from his brother. Till then, when both were joined, there was no pressure on me. But the moment he got separated from his brother, other brother, and got the property exclusively in his name, then he entered into the agreement and gave the notice to me. Gave the notice to me. From that act, my lord, it can nowhere be deemed, in my respectful submission before your lordship, nowhere can be deemed that his intention was honest to have the premises bona fide. From nowhere. And in the notice also, my lord, nowhere he has mentioned. I will take your lordship to the notice also. The two notices, these are exhibits, my lord. I will take your lordship to that because the record is already there. In none of the notice, he has mentioned that he requires the premises bona fide, for bona fide use.
What was the plea?
My lord?
What was the plea in the notice? He required it.
No, nothing. Pay rupees 2,000 if you vacate the premises on such and such date, or pay rupees 2,000 rupees per day. Per day. I will, if I can take your lordship to that is exhibit, my
We
lord.
will continue day after tomorrow.
My lord, day after tomorrow. My lord, I will be in Kohima for 2 days, 19, 20 and 21st. Let it be after that any day, my lord. On 25th, my lord.
25th.
Or yes, my lord.
That's part of it.
Yes.
Heard Mr. A. Sattar, learned counsel for the petitioner, also heard Mr. A. Tiwari, learned learned counsel for the respondent. Though this matter was heard at length, however, the hearing remained inconclusive. Let this matter be listed on 25th next hearing date. On 25th November as part heard matter. Let this matter be listed. This matter may be taken up as the first hearing matter on that day.
My lord, only sitting on an accommodation, my lord, item number 25, my lord. May I request, my lord, on the January, any day, the last week, preferably on 28.
I'm for developing 25, my lord.
Oh, yes, sir.
No fixed date in the month of, you choose a week.
Lord, lordship may kindly accommodate me at the house station.
Okay.
Your lordship may kindly, on 28 January, may not.
28 is a long time.
Item number?
25.
Will not reach, my brother. It's a new appeal.
Heard Mr. What is your name?
A. Hussain, lordship, before the vacation, any time.
No, A. Hussain, learned counsel for the appellant. Also heard Mr. B. Datta, learned senior counsel appearing for the respondent. This matter could not be taken up for hearing today due to paucity of time. Let this matter be listed on 28th of January.
Good.
May please.
Other leftover.
My lord, item 31, my lord. It was at my instance after filing early hearing petition, it was listed today. I am for the respondent. And
The appellant is there.
appellant is there.
Item number?
31. Sir,
Early hearing application was allowed.
out.
When do you want?
My lord, as per convenience of the court.
We cannot give fixed dates.
My lord, it was on the occasion it has been listed.
But
Because of the, in this case, my lord, though there is no injunction order, by filing writ petition, they have obtained the injunction. And money has been,
due to paucity of time, this matter could not be taken up for hearing today. Though it was listed today as an application for expeditious hearing filed by the respondent was allowed. Stop. Hence, let this matter be listed in the second week of December on date to be fixed by registry.
I pray.
No,
Date, my lord.
let the registry finalize.
Lordship, item number 20.
70 dismissed for default. One submission was made. Earlier stay order may kindly be vacated because there is stay order.
16 and 17. The stay order granted earlier. Consequently, the stay order granted earlier stands vacated.
May it please your lordship, lordship, item number 22, lordship. I think in item number 22, there is an IA for injunction, lordship. With some urgency, so lordship, date may be fixed, lord. IA is to restrain the respondents from proceeding with the construction work, lordship, during pendency of the RSA, lord.
The RS is fixed for hearing,
Yes, lordship,
final hearing.
final hearing, lordship.
So it will be finally disposed of
Yes, lord. Date may be fixed. lord.
in the second week of December on a date to be fixed by registry.
Obliged, lord.
My lord,
Remaining item,
Item
if
27.
there
my
is
lord,
no urgency,
It's a DRT matter. My lord has heard it. Can it be taken up on 2nd of December, my lord? That matter regarding the section 5 of Limitation Act, we have approached under 227.
it is
Against the-
partnered.
Not part her, it was, matter was admitted.
For the respondent.
She, my lord, she's for
Yes,
respondent.
lordship, I'm for the respondent. 2nd December is okay, Lordship.
Can it be taken about 2nd of December?
Okay, on 2nd of this.
Much obliged, sir.
With due respect, Lordship, Lordship, in the supplementary list, Lordship, item number 33 and 34, Lordship, in this case, Lordship, the appeal has been admitted without making payment. So, Lordship, any date, Lordship,
In February 2026, choose any date. You are saying any date. I am giving you option. Let it be fixed by registry. Let it remain as.
Lordship, in the, at least months, maybe next month,
March 2026.
Lordship, sorry, extremely sorry.
Let it be, let the registry fix the date. Remaining also,
Lordship, item number 20. This is the 5th occasion the my matter could not be reached. So my humble submission, kindly fix either on the November 27th or December 4th, if honorable, if it is possible.
no date will be,
Because this is the 5th occasion for the
no,
expedition.
we cannot help.
The December
The-
4th. It is 5th occasion.
Item number
Item number 20.
20 is
I am for the petitioner.
MFA. Second week of December on a date,
It's date to be
on a date to be fixed by registry. Registry will,
fixed. 5th occasion.
on that day you may mention.